The matter in which the publication was made in the newspaper. Yesterday it was submitted that the wakalatnama was filed on Monday, but I came to know that the wakalat was given to the department on Monday. The stamping punching is on Monday, but the on record it came yesterday only.
Wakalat is already not record, na?
Yes, my lord.
Okay, no. Yes, next.
Okay. Grateful, my lord.
Yes. Original citation. कौन सा? हैं?
1, 2, 3.
Number is there.
No, I'm there.
Where is the other party?
Well, they said any date is your lordship fixes a date. Well, we'll be here.
कब रखेगा?
I'll inform. Well, they're online.
Then 5
or CAV, but the learned counsel for the applicant has mentioned the matter and submit that he intends to.
Lordship, your lordship, am I audible? Am I audible to your lordship?
And according.
My lord, am I audible to your lordship? My lord, I'm online, your lordship. I am appearing for 2 and 4. Only difficulty, my lord, is that if your lordship, my lord, gives a short date.
Let the matter appear on. Let the matter appear on 18th July. 18 July at 2 p.m. 18 July at the top.
My lord.
At the top. Yes, next.
Item number 1.
Considering the above, this court did not find any merit in both the applications filed by the plaintiff as well as the defendants. GA3 as well as GA4 both have been dismissed.
Much obliged.
Yes, next. In view of the above, the defendant number 1 is directed to pay a sum of rupees 30 lakh being the principal amount along with the interest at the rate of 10% per annum from 19th June 2019 till realization of the total decretal amount.
Grateful. Item number 3, your lordship, is my contempt application. Your lordship, I think your lordship, Mr. Banerjee mentioned the matter that they wanted to surrender, but today your lordship, nobody is here. Lordship, warrant has already. That's my instruction. We have taken steps and the warrant has already gone. I think they were supposed to come today to
Yes, somebody is mentioned.
Mr. Suddhashotta Banerjee maybe.
Correct. But nobody is here. Let's pass on.
Lordship,
Yes.
Lordship, all I'm for the contemners, your lordship. All the 3 contemners are appearing personally before your lordship today. And
now they got the time to appear before the court after the issuance of warrant. We are more powerful than the court.
This is the status from the Ministry of Corporate.
Let them remain in the custody for 2 days.
Lordship, I asked them, they have been waiting.
Celebrate the Rath Yatra in the appropriate place.
Lordship, they have been waiting
for the
since
2 days.
Sunday, your lordship. I have
their conduct is not good. They required.
Definitely, your lordship is correct on.
Let them go.
Lordship, these are the 3 compliances. Your lordship, if your lordship
Still there. Names are still there. Your lordship. In NSC and Ministry of Corporate Affairs.
Lordship, but we have made the intimation to the NSC. Lordship, we have made the intimation to the NSC. The NSC has acknowledged it also. Subject, আপনাদেরকে serve করা হয়ে গেছে কালকে. Advance copy has been already served to the other side, your lordship. And if your lordship checks in the current master data, your lordship, these people's names are not appearing as the directors, your lordship. Lordship, my senior has.
চেঞ্জ করে দিয়েছে।
Page 7, my lord, we've taken steps to change the name also.
When after the issuance of the warrant, you held the meeting.
19th of
19
June.
June, when they appeared, and when the court has passed an order, let they remain for 2 days, for 24 hours minimum. That will be better.
No, my lord, I think this letter of 19 June was indicated, my lord. This was
Correct.
a
19
little
June only
before
they
that.
hold the meeting. 19 June only they hold the meeting. And as per the submission made by your junior on that day, there he told that the three directors are of 3 places. How this meeting was held?
Actually, you know, these 3 are not, they've been impleaded as directors, but they are not the directors of the company. This was informed to them also. I remember I had appeared on the first occasion when this matter had appeared. I had indicated this. I may not have given the names, but I had indicated that these 3 people are not the directors anymore.
But on your junior had appeared that they are the director. They are on the 3 different. He has not stated anything. They are not the director against whom the rule has issued.
So now, my lord, you should have a look at page 15. I've given the names of the persons who are actually in control of the company now.
They have been appointed in 2025, Your Lordship. 3rd April 2025, 14th April 2025.
This is also 19 June.
This is later.
Later. Before 19 June, who are the directors of the company? Before 19 June, who are the
I have resigned in November 2024.
Where is that?
And that you'll also find from page 16. And the new directors have been appointed on 3 have been appointed on 1st of April, 1 on the 3rd, and the 5th on the 14th of April.
Even the contempt application was moved. The first order was passed on 28th June 2024.
Correct. That's what I'm telling
They were there.
Thereafter, Your Lordship, these things happen.
This was with regard to the warrant of arrest. The conduct is not something that I'm really supporting here. Your Lordship has issued a warrant of arrest.
Have you received the copy?
Yes, Your Lordship, I have received today.
So what you are condensing?
Lordship, I have not seen. You have seen, Your Lordship, only the later dated 19 June 2025. I understand, Your Lordship, Mr. Banerjee never appears for this type of matters. Your Lordship,
Whoever
certainly
wants me to appear, I appear.
No.
I'm not choosy at all.
Now the thing is, Your Lordship, they have taken steps. What I am praying, Your Lordship, kindly, Your Lordship, don't dispense, Your Lordship, their personal presence.
That's right.
Lordship,
That
next
even
date may be fixed and let them indicate when these particular
Well, the
things will be
warrant of
removed.
arrest, Your Lordship will kindly consider staying, but do not dispense my personal appearance.
And Your Lordship, the cost
Allow
would
direct
be
me to come
imposed
back on the
them.
next day also.
Regarding Your Lordship, their presence since Your Lordship paper publication, and I don't think Your Lordship, Mr. Banerjee will
And I'll say
impose
this
regarding the cost today.
Manal, I'll say this while my clients are in court, they must realize that this is not a joke. Because I have also told them to be present and they keep trying, they try to make these excuses and they don't come. Directs a personal appearance, at least a warrant of arrest, Your Lordship will kindly consider staying till.
So and so appearing for the petitioner. So and so appearing for the alleged contemners.
Actually,
Who is Divakar Sharma? Dipesh Goda and Rajesh Pipalwa.
Why don't you all come? You were informed. So what if you're not there? You're party to the contempt application? You will not come. Then you go to jail.
Yes. Where is the
Still adamant, Your Lordship. That's the problem. They're still adamant. Yes, they are still fighting with their own counsels.
No, he's not.
Let them go to let them go to for constitutional law for some time.
This letter is there, they'll comply with it. Now that this has been done,
contempt application was
I will indicate the name of the present directors also.
So and so appearing for the petition, so and so appearing for the alleged contemners. Alleged contemners are present in person against the warrant of arrest issued against the contemners. Counsel for the alleged contemners has filed affidavit of compliance after serving the copy to the learned counsel for the petitioner. Let the same be kept with the record. By an order dated 19th of June 2025, This court has issued warrant of arrest against all the three contemnants on the ground that, in spite of several directions passed by this court, the alleged contemnants failed to appear before this court in person. After issuance of warrant, the and the alleged contemnants are present before this court in person through the learned advocate. Considering the above, this court find that the alleged contemnants are surrendered before this court against the warrant of arrest issued against the alleged contemnants by an order dated 19 June 2025. Let the warrant of arrest issued against the alleged contemnants be recalled. When is the date fixed? But
Tomorrow.
it is made clear that the presence of the alleged contemnants are not been dispensed with. Personal appearance of the alleged contemnant has not been dispensed with. Full stop. It is fixed tomorrow.
Yes, fixed tomorrow.
Tomorrow nothing will happen.
That matter appear.
How much time it will take?
7 days.
How much time it will take for changing? Let the matter appear on
How long will the process take? 21 days.
23rd of July 2025.
Lordship, only one thing, Your Lordship, like kindly don't give the cost to me. Let them
On
pay
that
the
I will decide on that.
Lordship. Otherwise,
So
Your
your
Lordship, they
lordship
will
has
not.
not
This is the
dispensed with
monetary
personal appearance. Please don't.
That's why I not dispense.
Yes,
So let them come.
Let the matter appear on 23rd July 2025. 5. The alleged contemnants are directed to appear before this court on the said date in person.
Grateful.
I'm grateful.
आज के हाँ नॉन कंप्यूटर
I'm the plaintiff in this matter, my lord. Pursuant to your lordship's last order, my lord, summons was again served on the defendant, my lord. It was served on 6th May 2025, according to the
Whom?
to the defendant, my lord.
To the defendant.
I'm the plaintiff, my lord.
You are for the plaintiff. It
And the
appears the tracking report, the item delivered on 24 January 2025.
I will kindly have a look at the report of the sheriff, my lord.
CS Com 470 of 2024. Neither the item delivered on 6th May.
6th May, my lord. Thereafter, my lord, they have not entered appearance. This is. So I was humbly praying if this can be listed as an undefended suit.
So earlier there was a report. What was that report?
Earlier there was a report, my lord. Will kindly come to the my lord's order dated March 25, 2025, my lord. There was a ambiguous report for which service was again directed, and this is the status.
So it was served on 6th May.
My lord.
They have not entered appearance.
My lord.
But you have to wait for some time.
But 30 days, it can be extended till 120 days, but 30 days are over, my lord.
It is over. I am fixing up to that. I am keeping this report. I am not passing an order for undefended because 120 days is there. If they will come and with the leave, I am fixing after that. Within 120 days, they will come and I'll see to that. If it is not, then the matter will be proceeded accordingly. Otherwise, they have to file the recalling order.
I bow down to you.
From suffering for the plaintiff. The plaintiff has filed the service report dated 12th June 2025, issued by the Deputy Sheriff of Calcutta, wherein it reveals that writ of summons was served upon the defendant through postal services on 6th of May 2025. The counsel for the plaintiff also handed over the report issued by the Deputy Registrar within bracket legal, in charge dated 16/6/2025, wherein it reveals that defendant has not entered appearance either in person or through advocate till 16th of June 2025. Let the you give the copy of the reports, huh? Let the copy of the report be kept with the record. Though the defendant has received the writ of summons 6th May 2025, but has neither entered appearance nor has filed written statement, but for the interest of justice, the case is adjourned. Let the matter appear on 4th September 2025. दे दो से जेरॉक्स ले लेना. Yes, next.
Your Lordship, this is in respect of your Lordship's order dated June 11, 2025, Lordship, the copy of the order. Your Lordship, by this order, your Lordship has given direction to upon the department, your Lordship. What has happened, your Lordship, that when we went to the department, they said that we are supposed to serve to the concerned.
Problem is that on the last occasion, I passed an order on the pretext that the Safina has been served. But subsequently, it is found and I pass an order to the authority why they have not appeared. Subsequently, when the department inquired, it was found that your advocate on record received the summons, Safina. It was not served to the concerned party.
It was informed, your Lordship, that the department will serve.
That's why now when I ask, the department is telling that since beginning there is no procedure for summon service of summon of the Safina by the department. Well, okay, I will pass the judicial order what the office is to do.
Oblige, your Lordship. Oblige, your Lordship. And your Lordship, the
Petty matters, Lordship have to intervene.
That is the problem. Many things. If I call the office and say what is my lord, it is going for the last several years. This is a practice. There is no procedure, there is a practice.
there's a practice. There is no law.
Actually,
There-
recall, there used to be some elderly people in the department when we joined. This
Then we are
application,
taking-
whether it will be master summons or it will be notice of motion, we used to go to ask them. And how the supplies to
Correct.
drawn up, we had to go to ask them. Today, there's nobody department
Knows.
who knows anything. Well,
Sir,
that's the whole problem.
I also
That clan
this
is
my personal
gone.
experience also. When I joined the bar, I used to sit in the office of the staff of the
Yes, yes. They used
concern
to teach us
section.
many
Yes.
things.
That is a school, my lord. That is the institution where we
But
learn.
I find nobody the staffs are because the old persons are
Or
retired.
that's the whole difficulty.
Nothing is there.
And that has not passed on, unfortunately.
The same thing in the letters of administration of probate. I find that the surety that is to be given, that is not the procedure. Only indemnity has to be given.
Yes.
But they are taking the total surety and all these things. What is going on? I don't know.
And your lordship, next second thing is your lordship, Mr. Manoj Kanti Dotto is not from the GPO Kolkata. He is from the Noihati SO post office, your lordship. That has to- Noihati, your lordship.
As though the matter is fixed on
18th July. your lordship.
18th of July 2025, but the matter is listed on receipt of the
Your
report
lordship, extension has to be given, your lordship.
and receipt of the report from the master and official referee dated 24th of June 2025. From the report, it reveals that as per the order passed by this court dated 11th of June 2025. No. What is the earlier order? पहले order का है?
Fix, madam.
As per the order dated 29th June 2025, the department has issued the subpoena upon the learned advocate on record of the plaintiff for service upon the concerned persons, namely Mr. Ranajit Chakravarti, seal bailiff and Mr. Manoj Kanti Datta GPO Netaji Subhas Road, Fairly.
Lordship, Noihati.
Huh?
Post
I
office.
will. Police. Full stop. The matter was taken for and the returnable date of the subpoena was fixed on 11th of June 2025. On 11th of June 2025, the other report though last वाला 11th of June 2025, the registrar original site had submitted the report dated 10th of June 2025, stating that the writ of summons and the subpoena has been separately issued upon Mr. Ranjit Chakravarti and Mr. Manoj Kanti Datta. It was also mentioned that the same has also been received by the advocate on record of the plaintiff for service upon Ranjit Chakravarti as well as Manoj Kanti Datta. Though none had appeared on behalf of, and though Mr. Ranjit Chakravarti and Manoj Kanti Datta had not appeared before this court in spite of issuance of subpoena, this court has passed an order directing the master of this court as well as Director of Postal Services, South Bengal region to submit report why the said persons are not appeared before this court in spite of issuance of subpoena. When the London master of this court, in compliance of the order passed by this court dated 11th of June 2025, has taken steps and found that the subpoena was not served upon the said persons, but only the subpoena was issued to the London advocate on record for service, but the service was not completed. Thus, the master has filed the instant report. Consider the full stop. This court find that by an order dated
का नाम दे देना
29th April 2025 has directed for issuance of subpoena upon the above named two persons, but the office of the London master, who has issued the subpoena, office of the master, office of the London master has issued the said subpoena to the London advocate on record for service. The said practice of the office is deprecated. If any order is passed by this court for issuance of summons or subpoena or any notice by the office, it is the duty of the office to serve the notice, subpoena or any summons through the process, not through the advocate on record. Accordingly, the London master is directed to serve the subpoena upon Mr.
Ranjit Chakraborty,
Mr. Ranjit Chakravarti, Seal Bailiff, and Mr. Manoj Kanti Datta. What is the post? Manoj Kanti Datta?
the letter is there, your lordship.
Master.
No, yes.
He'll beat postman.
Manoj Kanti Datta beat postman, posted at
Nuihati.
Nihati, SO Post Office, Talpukur Road, Ward number 23, Nihati.
Lordship, the matter
Through the office of the Sheriff of this court.
Lordship, the matter can be kept on
Let
place
the
of
subpoena be issued upon the above said two persons with the direction to appear before this court on
29th of July, your lordship. My senior, learned senior is
29 July.
As
29 July 2025.
court's convenience is first, my lord.
Your lordship,
That you have learned.
No, this court is also taking
Yes.
convenience of the advocates
We know
also.
that.
your lordship is fixing time, your lordship, 11:30.
29 का time है कुछ?
12:30.
12:30.
Obliged, deeply obliged.
Grateful.
Well,
Lordship, we are
one
taking
thing,
inspection today.
the last order, the beat post spelling is BIT.
Acha.
There should be BEAT.
Now I corrected the
Hello.
order. It will go to that. Nihati it will go. BEAT.
Lordship, we are taking inspection today, your
Beat
Lordship.
officer na?
Beat postman
Beat
যেটা বলে
postman
সেটা
है ना?
BEAT.
BEAT.
इसमें बोलना ना
Not BIT.
Oblige, your Lordship.
And if they file in the meantime, the supplementary
So
that will be
the
copy should be
petitioner
given.
takes the plaintiff is directed to take necessary steps for filing requisites before the master within a week from date.
First of all, my apologies for appearing online yesterday, Your Lordship.
No,
I'm told I was not properly audible.
That is no
yesterday.
problem.
Lordship, insofar as this matter is concerned, you will see there are two suits, CS 565 and CS 564.
Correct.
Lordship would recall this is that matter where I had filed an application for judgment upon admission.
So yesterday the judgment was given. I was confused because the Honorable Appellate Court has passed an order.
There are two orders, in fact.
Now kindly come to that. Paragraph 18. Paragraph 18. Since the application for judgment upon admission and the injunction was heard and the said matter was made CAV.
Yes, Your Lordship.
What is that?
It was.
So what has happened to that?
No. Your Lordship would recall. I'll just appraise Your Lordship. This is that matter where Your Lordship had.
This is with regard to which 565?
565. 565 is this particular order which you're reading at para 18, Your Lordship.
Correct, but 565, you have challenged that order.
Yes, Your Lordship.
And 565, both the order has been disposed. Application.
May I just appraise Your Lordship what has happened? In 565 and 564, we had filed GA1 and GA2.
Correct.
GA1 for judgment upon admission and injunction, protective orders. 564, identical. GA1, GA2. Now, GA2 was filed by the respondent for revocation of leave under clause 12.
Correct.
Now, GA1 was heard at the cusp of after GA1's hearing was completed, GA2 was filed. Because Mr. Banerjee appraised that we are challenging the jurisdictional aspect. So, Your Lordship was also pleased to hear GA2. Then both matters were reserved. Then finally, Your Lordship rejected GA2. The defendant's application for revocation of leave under clause 12. But since there was some confusion regarding the location of registered office, insofar as 564 was concerned, Your Lordship, however, did not pass any order, refrained from passing any order, insofar as 565 and 564 both are concerned. GA1 in both of these suits. Now, apropos that, we had preferred two separate appeals. One against GA1, arising from Your Lordship's order in GA1, the common order, and one in 564. Now, insofar as 564 is concerned, that was the particular suit where there was actually a confusion regarding the location of the registered office. Insofar as 565 is concerned, there was no such confusion. So in light of that, we pointed out that although a common order was passed, there was no such confusion insofar as location of registered office in 565 is concerned. Apropos that, para 18 is the leave that was granted, the request that was recorded, that let the honorable judge can GA1 can be heard.
Manu, 564 का है. उसका फिर क्या हुआ? उसका
Now 564 I'll appraise, Your Lordship. Now in 564, a separate order dated 6th of January 2025 was passed. In that, it was mentioned that since there seemed to appear to be some incongruous statements in the pleadings in para 4 and para 5 of the plaint, let an appropriate application and or amendment be carried out, application be made before the learned judge, so that in view of that application, that matter be proceeded with. We are not interfering with that order at this stage, insofar as 564 was concerned. So we have preferred a separate application clarifying that incongruity. We assessed, it transpired that there were no incorrect statements, there was nothing wrong that was pleaded, but there was some confusion. We are seeking to clarify that by way of a separate application, which will be in 564, which will appear, which is
25, item number 24.
Item number 24, which is already appearing, Your Lordship, today. Now, that is insofar as 564 is concerned. Now, insofar as 565 GA1 is concerned, Your Lordship, there was no necessity for any clarification, anything. Your Lordship was just requested to consider it on merits and pass an order. And Your Lordship had heard me extensively on that.
I have no problem. That is the problem. Paragraph 18 is the problem now. Read the paragraph.
Since the application for judgment upon admission and injunction was heard, and the said order was made CAV,
then
we request the learned judge to decide the said application on merits until such time respondent shall deal with the assets and properties. We are not concerned with the later protective part. But
the request to the learned judge to decide the application on merit. But that is already decided.
No, Your Lordship has not passed it.
What is the order?
Passed any order, Your Lordship.
564 का order तो ना?
565, Your Lordship.
565 already disposed of. Kindly see the
Lordship,
J1 and J2.
I'll tell you, Lordship. I'll tell you, Lordship.
J1 and J2.
Yes. 18th November
Otherwise,
2024.
I will send to the division bench reference.
May I just?
Why the court can take the burden? Kindly come to the paragraph 44 and 45.
Yes, Your Lordship.
In view of the above, GA.com 1 of 2024 filed by the plaintiff and GA.com 2 of 22 filed by the defendant, both are dismissed.
Yes, Your Lordship. But Your Lordship has not passed any order on merits. It was only on the ground that the issue of jurisdiction
Court has not
is pending.
decided that the merit. Court has passed an order CAV. So it was made a wrong submission before the appellate court. It was CAV, but it is disposed of.
No. We have submitted. It was disposed.
Where is the CAV?
Yes, Your Lordship. That was the recording. But if Your Lordship comes to our submission, we had category. Otherwise, how can we make a appeal?
But I cannot. Keep this. Set my paragraph 18. The court has directed to dispose of, but that has already been disposed of.
Your Lordship will kindly come to para 13.
Para 13 of?
Para 13
appellate order?
Of the appellate order. 6 January.
Yes.
Mr. S.N. Mitra, learned senior counsel appearing, Harleen Jairat, etc. The fourth line, it is submitted that in view of a clear case of admission and a fact that iron ore has not been supplied till date, there is a clear apprehension that unless there is some protective order passed, Mr. Mitra submits that while the learned single judge has dismissed the application for revocation of leave, the learned single judge did not decide the issue. It is not that it was only made COV. Did not decide the issue of judgment upon admission on the ground that unless territorial jurisdiction of the court is decided, no order could be passed. So we have never submitted that it was not disposed of. We had merely submitted that the issue on merits was not decided. And that issue needs to be decided today, Your Lordship.
Read the 13 and 18 together. CAV. Court has not stated that the court has not decided the issue. Court has stated that the CAV.
Your Lordship will kindly come to para 15 words also.
Correct. You mentioned whatever
order,
it is, but the
and
court has
focused on
recorded 18.
territorial.
Court has recorded 18. Had the said matter was made CAV, we request the learned judge to decide the said application on merit. Till such time, the response shall continue. That application already be decided by the order dated.
Absolutely. To that, there is no dispute that it
order
was decided.
1811.
Our submission was merely that it was decided, but the issue of judgment upon admission has not been.
What will happen to this direction of the division bench?
The direction, Your Lordship, is if Your Lordship
not override the division bench order.
No, Your Lordship, I'm not calling upon Your Lordship to override the division bench order.
So I am sending
we are
merely the division bench. This is
we are merely beseeching Your Lordship to pass an order on merits on the judgment.
I can, no problem.
There is no fetter to Your Lordship's jurisdiction.
No,
that is all.
This will
we will get it corrected then. We'll get it
either you correct, then otherwise I have to make a reference.
No, we will get it corrected. We will take appropriate steps. In the meantime, insofar as that CAV is concerned, it was disposed of.
Disposed of without deciding that.
Without deciding the issue.
No problem.
We will take appropriate steps in that regard. And in the meantime, since there is no fetter, if GA1 of 565, that can be placed on any convenient date, Your Lordship, for disposal on merits. That is my limited request.
Where is the other party?
It is made undefended. Subsequently, Your Lordship would recall, their right to file written statement was closed by GA3.
But hearing of the GA1 is to be given, the notice is to be given.
Here, that we will give.
Okay.
But we are told that nobody was representing, their lawyer also recused. We will give a notice. We don't even know who has entered appearance in place and stead of the last previous advocate on record.
Suffering for the plaintiff, none appears on behalf of the defendant. Counsel for the plaintiff submit that in In view of the judgment passed by the Honorable Appellate Court dated 6th of January 2025, GA Form 1 of 2024 is to be read as heard afresh. According place for fixing the matter and date for fixing the matter on a specific date and time. Full stop. This court perused the judgment passed by the Honorable Appellate Court dated 6 January 2025 in AO-Com 2 of 2025 with CS-Com 65 of 2024, wherein in paragraph 18, the Honorable Division Bench has passed the following order. Paragraph 18 quoted. Quote, Paragraph 18 quote. Set out. Okay. This court find that GA. This court find that the application filed by the petitioner plaintiff being GA-Com 1 of 2024 was dismissed by an order dated 18/11/2024, and as such the counsel for the plaintiff submitted he will take appropriate step for correction in the said order before the appellate court. Let the matter appear due the date. What time? 18 July at 11:30.
Very well. May I just for once check? Instead of 18th, could it be either 17th or 21st of July? I'm not sure.
कोई दूसरा डेट है? आगे देखो कोई दूसरा डेट.
21st.
5th of August. What time? 5th August 11:30.
Very well.
5th of
In the meantime, we'll take steps.
5th of
I'm
August
deeply
11:30. Yeah. Yes. Next.
And this I'm sorry, Your Lordship, insofar as this direction is concerned, this is only insofar as CS 565 is concerned.
565 only I pass.
I'm just clarifying. Unless there is a confusion. I'm deeply apologize.
I am appearing on behalf of the plaintiff petitioner, Your Lordship.
8.
Yes, Your Lordship.
Yes.
In this matter, Your Lordship, the defendant was being represented at certain point of time.
You are appearing for?
The plaintiff petitioner, Your Lordship. The sole defendant was being represented at certain point of time. Thereafter, they stopped appearing. However, Your Lordship was pleased to grant them a further opportunity and directed us to serve again upon the defendant, which we did. And on the last one occasion, they had appeared, Your Lordship. Now, Your Lordship, there are 3 applications pending in this suit. All 3 are mine. The first application, GA1, is for attachment and injunction. GA1 is for attachment and injunction.
Correct.
GA6 is for judgment on admission, Your Lordship. Your Lordship, during the hearing of GA1
GA6
is for judgment on admission.
What about GA3?
GA3 is my application under section 340, Your Lordship.
Anything remain further?
Your Lordship?
Anything remain in the TPC or CRP? Not.
Your Lordship, while hearing the GA1, was pleased to observe that it's a clear case, and Your Lordship was under the impression that it was a judgment for admission application, Your Lordship, and thereafter we had filed this application, Your Lordship. Your Lordship, may I place the judgment on admission, Your Lordship, straight away, Your Lordship. Your Lordship, we had advanced a sum of rupees 1.5 crore, Your Lordship, as stated in paragraph number 4, Your Lordship, of the petition at page 3.
Page 3?
Yes, Your Lordship, page 3 of my application.
Yes.
6. Para 4, Your Lordship. Sometime in December 2019, the respondent had requested the petitioner
Page
for
3 of GA1.
no GA6, your lordship.
Page 3, paragraph
4.
Yes.
If I may please, sometime in December 2019, the respondent had requested the petitioner for an advance of rupees 1.5 crore towards supply of raw cotton bales, as the respondent was in some financial constraint. The respondent also agreed to pay interest at the rate of 18% per annum to the petitioner till such time that the supplies aggregating to rupees 1.5 crore, being the advanced amount, was totally cleared by effecting such supplies. Your lordship, thereafter, we have in paragraph 5, we have pleaded the jurisdiction. Then, if I may straight away come to paragraph 6, your lordship, this entire payment was made over in a single transaction by way of RTGS transfer made by the petitioner on December 31 to 2019 from its bank, so and so. The transfer was thus made from second floor NS Road, Ganesh Market, Kolkata 7 lakh 1, before being the office of the Tamil Nadu Mercantile Bank. Your lordship, the bank statement has been annexed as A, which is
What is the total amount?
1.5 crore, your lordship.
1.5.
Yes, your lordship.
Where is your transaction in the annexure A?
Your lordship. No. Your lordship, December, I'll just place
13 December.
31st December 29. Your lordship, it is at page 19, your lordship.
Page 19?
Yes, your lordship, page 19. 31st December, your lordship finds RTGS Mahavir Ginning, the respondent, the proprietorship firm of the respondent defendant, your lordship, 1.5 crore.
Yes.
Your lordship. We had made over. Now, your lordship, if I may please, paragraph 8, 7 and 8. The transaction is not in dispute and indeed stands admitted by two sets of admissions by the respondent. 8. The first admission by the respondent was made through an electronic email of 5th February 2020, which was received by the petitioner at its office. Your lordship, that email has been disclosed at page 28 of my petition, your lordship.
Page 28.
Yes, your lordship.
Yes.
If I may please, page 28.
Yes.
Respected sir.
Yes, got it. Yes, next.
Oh, very well, your lordship. Then paragraph 9, your lordship. The second set of admission was made by the respondent by supplying 398 bales of raw cotton to the petitioner. The value were appropriated by the petitioner towards the advance payment made by it to the respondent. The respondent, in terms of the agreement between the parties, made supply of raw cotton bales in the aggregate value of rupees 76,65,422. The said value of bales of raw cotton was duly appropriated towards the advance payment made by the petitioner to the respondent of rupees 1.5 crore, and after giving credit for all supplies made, a sum of rupees 1 crore 7,58,371 is due and payable by the respondent to the petitioner in terms of the particulars mentioned hereinafter. Your lordship kindly sees the particulars. A, the total advance given 1.5 crore. B, we have given credit of the supplies made, your lordship, of 76,65,422. C is the interest debit note sent by the petitioner to the respondent for the period 31st December 2019 to 29th February 2020, 4,80,000. Your lordship. D, less miscellaneous ledger account.
76,65,422.
That is, we give credit. We gave credit because of the supplies made of 398 bales of raw cotton,
Okay.
stated in paragraph 9, your lordship.
Okay.
We have given credit of that. D, miscellaneous ledger account debit credit adjustment between the petitioner and the respondent. And E is also the interest debit notes. And finally, your lordship, the 18% interest that we have charged. Now, your lordship, I must point out, we had issued a notice on 20th January 2022, which is appearing at page 29 of our application, your lordship.
Correct.
Where we have clearly stated, if I may place, paragraph 2. Please note that sometime in the year December 2019, you had approached our client for an advance of rupees 1.5 crore towards supply of raw cotton bale to be made by you within 15 days from receipt thereof. It was promised by you that in the event you fail to make supplies, that you shall refund the same said sum together with interest at the rate of 18% per annum. It would be pertinent to mention that you and our client had a running account. Believing your representations to be true and correct, on 31st December 2019, our client had advanced 1.5 crore. And then, your lordship, in the next paragraph, we apprise of the email which was sent by the defendant, your lordship. And thereafter, they admitted the sum advanced. And thereafter, your lordship, we had said that rupees 1 crore 7 lakh 58,371 is due and payable. Because after the supply of 398 cottons of bales of cotton, and also the interest. Hence, we are seeking a judgment on this sum, your lordship.
1 crore 16 lakh.
1 crore 7 lakhs.
One
Along with interest, your lordship.
1 crore 7 lakh is the principal.
Yes, your lordship. Your lordship,
principal.
The
Because
principal.
you have given 150.
Yes.
76.65 you have received the materials.
Yes, your lordship.
Correct. And you have less. It has to be less. Then you have claimed the interest.
Yes, your lordship.
When the materials were received by you of the 76.65 442.
Your lordship, it ought to be in the period 29th February 2020. Your lordship, kindly sees the entry C in the particulars. That the interest calculation starts from when I had advanced the amount, and your lordship, it ends, the first calculation ends on 29th February when we received the materials. And that's why we had given this breakup, your lordship. Your lordship, I'm led by Mr.
Then
that's why we had given this breakup of the interest.
Where is your pleading that you have received the material on so and so date?
Your lordship, that is not appearing here.
Okay, next.
And your lordship,
1 crore 107.
Yes, your lordship.
Plus interest.
Yes, your lordship.
18% interest. That is,
yes. Okay. And we had given this notice, to which they had never replied.
They are not given any reply
to this notice.
Okay. They are not filed
and neither there is any affidavit in opposition on record in this application, although your lordship had given numerous opportunities to file the same. We had even served by your lordship, pursuant to your lordship's direction on them several occasions. They had appeared, but they have again stopped appearing.
Okay, next. Anything further?
No, your lordship. Hence, we are seeking for judgment on admission of such sums in terms of prayer A, your lordship. Your lordship kindly grants leave to Mr. Ghosh is leading me.
My lord.
Yes.
If your lordship, my lord, doesn't, my lord, take this 76.65 422, then, my lord, your lordship can simply go by their own admission, where they say, my lord, they have, my lord.
No, I am telling with regard to.
I know. I have understood that pleading is not there. I must be candid, but, my lord, your lordship can get
not
from the
76 is not the point here.
I am giving them credit. So,
So that is not
so C and D.
with regard to the claiming interest.
Yes, so that's why what my learned junior said, there is no pleading, I must bow down. But my lord, that's why we have divided these periods from which your lordship can get, my lord. And they have got numerous opportunity to come and tell your lordship on oath
And
that this is not the correct.
With regard to the D, the miscellaneous ledger account.
Yes, my lord.
What is that? 1/1/2022, 3,09,786. What is that?
No. But this, my lord, your lordship, my lord, this is also, my lord, I have given credit to them. Some, my lord, adjustment on my account, this is also credit. So if they don't want to take the credit, my lord, it's up to them. And then, my lord, interest, my lord, from 2020 to, my lord, December 2021, 32 lakhs I have calculated.
Okay.
On as per the debit notes. My lord, GA1, which is the other GA, which is your lordship, is also appearing in your lordship list. My lord, Justice Arindam Mukherjee's order, kindly, my lord, takes 20th November. This is the order that is, my lord, subsisting. My lord, there's all. No, I'm sorry, my lord. It was dismissed for default, but not, my lord, reinstated. But this is the last order we were enjoying. And my lord, there is no change of circumstance from then. My lord, this is a total amount of, my lord, 75 lakhs was, my lord, directed by them to be kept aside in their account, my lord, which they, my lord, the order was thereafter, my lord, vacated because of dismissal of the suit.
So
but
what
I am
happened?
saying
GA1 is dismissed.
Was dismissed, now restored.
Now restored.
Now restored. They had filed an affidavit, my lord. Nothing there, my lord. No defense disclosed.
What will happen if it is a judgment upon admission?
So, my lord,
decided?
I would beseech your lordship, if your lordship is with me and passes a judgment upon admission, then, my lord, in GA1, that order needs to be, my lord, extended till the time the decree is satisfied. If your lordship is with me, that GA6, there should be a judgment upon admission and there should be a decree.
No, if the judgment on admission should have been dismissed.
Yes.
Dispose of entire.
Yes, and
So
I'm saying
the question of GA1 does not arise.
no, I'm saying your lordship, if your lordship is with me that their decree is to be passed, your lordship can say that till the decree is secured, they should keep this amount. Otherwise, my lord, knowing that the decree is passed, if they withdraw that amount, that also, my lord, should not inure to their benefit, my lord. Those are my submissions on GS6.
That order is continuing?
No, it has not been continuing. So it is up to you.
And what about your 340?
340, my lord, if I get, my lord, these things, my lord, I'm
So
not.
can I dispose of all?
Yes, your lordship will dispose of GA6, GA1, and 340. GA3. Yes. 1, 3, and 6.
Supreme for the plaintiff. None appears on behalf of the defendant. The plaintiff has filed an application being GA1 of 2022, praying for
GA1 of 2022
entry mode for security of देखने तक क्या प्रेम में भरोसा praying for appointment of special officer,
yes, madam,
public receiver, and injunction. The plaintiff has filed another application being GA3 of 2023, praying for judgment upon admission.
That is GA6, my lord.
GA6 of 2024. GA6. The plaintiff has also filed an application GA3 of 2023 under section 340 of the CRPC. Full stop. By an order dated 9th June 2025, this court has closed the chance for a filing affidavit in opposition by the defendant, as several opportunities are given to the defendant, but the defendant has not entered up and not filed the affidavit in opposition in connection with GA6 of 2024. According to this, when the matter is called today, none appears on behalf of the defendant, and accordingly, counsel for the plaintiff has proceed with the GA6 of 2024, wherein the plaintiff has prayed for judgment upon admission. Counsel for the plaintiff submitted that in the month of December 2019, the defendant had requested the plaintiff for an advance of rupees 1.50 crore towards the supply of raw cotton bales as the respondent was in financial constraint. As per the request made by the counsel made by the defendant, the plaintiff had agreed to pay the interest, and the defendant has also agreed to pay interest to the plaintiff at the rate of 18% per annum till the period when the supplies of aggregating to the sum of rupees 1.50 crore is totally cleared by affecting such supply. Cleared by affecting such supplies. Counsel for the plaintiff submits that on 31st of December 2025 and 2019, the defendant and the plaintiff has transferred the amount of rupees 1.5 crore in the account of 1.50 crore in the account of the defendant. After receipt of the said amount, the defendant has not supplied the materials, and by an email dated 5th of February 2020, the defendant has admitted that they have received the advance amount of 1.50 crore against the cotton bills, but because of some problem in their ginning, GINNING, is not working. So the defendant informed that they will return the said amount on or before 15th of February 2020. Counsel for the plaintiff submit that in the meantime, the defendant has supplied the cotton mills for a sum of rupees 76,65,420.22, and thereafter neither the materials was supplied nor the amount was returned to the plaintiff. Accordingly, the plaintiff has sent a notice to the defendant on 20 January 2022, calling upon the defendant to pay the balance amount along with the interest at the rate of 18% per annum within 15 days from the date of receipt of the notice. The notice was duly served upon the defendant, but in spite of receipt of the notice, the defendant has neither sent any reply nor paid the amount as requested by the plaintiff. The counsel for the plaintiff submit that from the document, that is the bank account statement of account of the plaintiff, clearly proves that on 31st of December 2019, the plaintiff has transferred an amount of rupees 1.50 crore in the account of the defendant, and by an email dated 5th of February 2020, the defendant has admitted that they have received the amount of rupees 1,50,000, 1 crore 50 lakhs, but could not supply the materials, cotton bales, due to some problem in the machinery, and inform that they will return the said amount by 15th of February 2020. It is admitted by the plaintiff that out of 1.50 crore, the defendant has supplied the materials to the tune of rupees 76,65,420.22, and further an amount of rupees 3,09,786 was adjusted in the miscellaneous ledger account for the period from 1/1/2020 to 31st of March 2020. Accordingly, the plaintiff submits that the plaintiff is entitled to get an amount of rupees 1,07, submit that the plaintiff is entitled to get interest from 31st of December 2019 till 29th February 2020, and subsequent period till the disposal of the present till the realization of the total amount. Counsel for the plaintiff submit that the defendant has unequivocally admitted that the plaintiff has paid the amount, but the defendant does not neither return the amount nor has supplied the materials as agreed by the defendant, and as such, this is a fit case for grant of for passing judgment upon admission. Heard the learned counsel for the plaintiff produce the materials on record. The plaintiff has disclosed this statement of account wherein it reveals that on 31st of December 2019, the plaintiff has transferred an amount of 1.50 crore in the account of the defendant. Defendant by an email dated 5th of February 2025 and 2020 has admitted that he has received the said amount but is not in position to supply the materials due to problem in the machinery, and he will return the amount by 15th of February 2020. Full stop. In the meantime, the defendant has supplied the material for an amount of rupees 76,65,422. Subsequent. The plaintiff has also issued the notice to the defendant calling upon the defendant to payment of the balance amount, but the defendant has neither given any reply nor has paid the amount. This court found that the plaintiff and the defendant has unequivocally admitted the claim of the plaintiff by a email dated 5th of February 2020 and also not given any reply to the notice dated 20th January 2022, wherein the plaintiff has categorically claimed an amount of rupees 1,07, 58,371 along with interest at the rate of 18% per annum. This court found that the plaintiff is this court found that from the document disclosed by the plaintiff, which has not been reverted by the defendant by any way, either by filing affidavit in opposition or not reverted by filing affidavit in opposition. Accordingly, this court find that the defendant has unequivocally admitted the claim of the plaintiff and the plaintiff is entitled to get the judgment on upon admission. In view of the above, the defendant is directed to pay the amount of rupees 1,07,58,371 along with interest at the rate of 18% per annum from 1st January 2020 till the realization of the decretal amount. Accordingly, GA1 JCOM 6 of 2024 is disposed of. CSCOM number is CSCOM 415 of 2024 is disposed of. The department is directed to draw the decree. Full stop. As this court has disposed of the suit itself, accordingly, the applications filed by the plaintiff being GA1 of 2022 and GA3 of 2023 are also disposed.
My lord, my witness was in the box. I'm for the plaintiff. His examination in chief.
Yes.
The lordship's leave. May I continue? Exhibit A by 1 যেটা ছিল, exhibit A by 1 and A by 2 ওটা একটু লাগবে।
Okay.
Okay,
Thank you.
What is your name, sir?
My name is Amit Agarwal.
Resume, huh?
Spelling?
AMIT
AMIT
AGARWAL.
In the position time. First is deposition. Question number. Then a question 6, 7, 8 যেখানে আছে। G question 6, 7, 8. 7, 8. Shown answers to questions 6, 7, and 8 of the examination in chief of the witness. Within bracket eta, tarpore. Witness, I am showing you a document. It to hand over করুন. Referred to in paragraph 1 of your affidavit on evidence. Please go through your answers to question numbers 6, 7, and 8 of your deposition and tell my lord, what do you have to say regarding the contents of this document?
My lord, all the contents are true and correct.
Where is the original of this document?
This is the original document, ma'am.
My lord, may I be permitted to have this tendered? On the last occasion, already the signatures were identified and they were marked and exhibited also. So, with your lordship's leave, this is the board resolution by which he was authorized to come and deposit.
Yes, exhibit.
Exhibit, this would be Exhibit A because the signatures were marked as Exhibit A by 1 and A by 2.
A. Exhibit.
A.
Already exhibited.
No,
The signature
Exhibit A.
exhibited,
Yes, but the document was
not.
not.
The document
Today, the document is
Okay.
being exhibited. Exhibit A.
Exhibit है क्या है?
Where is it?
Already exhibited.
My lord, has to be the signatures has to be exhibited from the document. How otherwise? How will the
Yes,
signatures be
the
exhibited?
signatures.
I already exhibited.
Very well. Shown the second
Exhibit
email
open.
appearing at shown the second email appearing at page number 33 of the judge's brief of documents, volume 1.
ये अनुतोष.
Kindly tell my lord,
Chief में तो कोई exhibit है.
what is this document? (33) page.
My lord, this document is regarding the intimation that defendant number 1 and 2 are coming to Kolkata for this project confirmation.
Who has written this email
This
and
email,
to whom?
first of all, this email has been written by the defendant number 1 to the defendant number 2, keeping CC to him and directly to me. And then the same has been forwarded to me by the defendant number 2 to me again as an intimation on the very next day. Defendant number 2 on 13 September 2012 at 13:22 hours, intimating that they are coming to Kolkata on 19 September 2012.
Shown page 33 top within bracket of the judge's brief of document volume 1. একদম top page এ
Page 2.
Witness, can you tell this honorable court what is this document?
My lord, this document says that they have again sent me the quotation attached herewith, and the quotation and the layout of machines were attached in this email. And this email has been sent by them on 30th July 2012 at 10:48 hours. It has been sent by defendant number 1.
He's looking at. No, that is not the judge's brief of documents. That's the list of exhibits. It's a completely different document. Judge's brief of documents. That's not the one. It would be a compilation in 2 volumes, hardbound. দুটো আলাদা আলাদা ভলিউম হবে জাজেস ব্রিফের। ওটা না, ওটা অ্যাডিশনাল ডকুমেন্টস, এছাড়া দুটো ভলিউম আছে। हाँ এরকম। ম্যাডাম মে আই হ্যান্ড ওভার মাই কপি?
हमारे पास नहीं है।
এরকম হবে।
Have you filed? It is filed in the court.
Yes, Your Lordship. The documents were all before Your Lordship. In fact, I started off with the examination in chief on the earlier occasion. 29 questions were put.
And then in the examination chief also, you have
Yes.
shown this resolution.
Yes.
A1 exhibited in question number 8. But
Yes, question number 8, if Your Lordship look at,
A by 1, A by 2.
by 1 and A by 2 of the
Exhibit is
signatures.
not there. It is marked on the same day as per our this paper.
Deposition, it shows that it is exhibited A by 1 and A by 2.
Deposition doesn't show A, but
Yes.
our record says it was exhibited.
That is why I put again the question once again on the
Then
document.
I would be humbly submitting, then may the deposition be corrected, my lord.
It can wait because I
No,
don't
no,
want
I
to.
am not saying it to be done now. I'm just saying if my lord makes an order that the
Please, after
deposition.
two
That's why. That's why. That's why informing both of
Yes.
you. So I will record an order and it will get.
Yes, yes, absolutely.
Not asking for postponement. I'm only.
My lord, may I just hand over a copy? আগের কোয়েশ্চেনটা জাস্ট রিপিট করুন ওনাকে, ওনার আনসারটা খালি কেটে দিন। এটা কি অরিজিনালটা ওদের কাছেই থাকবে? ওটা বলো। I'm drawing your reference to the top of page number 33.
My lord, the page number 33, the top portion says that this email has been sent by defendant number 2 to me on 13th September 2012 at 13:22 hours, where he has informed me that they are visiting Kolkata on 19th September 2012 at 8:30 a.m. 8:30 a.m. in the morning.
What was the occasion for defendant number 3 to issue this letter, this email, according to you?
This was for the discussion and finalization of this project, which I was going to put for my business. उसमें डॉक्यूमेंट अलग था ना?
Okay, I'll clarify it. Who is Mr. Urmesh Singh?
Urmesh Singh is an agent, Indian agent of the defendant number 1 and 2.
Yes, my lord, as rightly pointed out by my advocate on record, by the order of 6th of January 2025, it is recorded that the evidence of affidavit is filed by PW1 may be kept in record along with judge's brief of documents. So everything was
No,
kept.
no, it might, because no, it was the other court. No? So
Yes,
record has not.
yes, maybe the records have not come in. ঠিক আছে তুমি দিয়ে দাও বা ওই কোর্ট থেকে এখানে আনিয়ে নিও ব্যাস আর কিছু না। Where is the original of this document?
This is the original document, and it has been already been inspected by the defendant's party.
Did you offer any inspection of the original of the document?
Yes, and they have already inspected it.
My lord, may I be permitted to have this tendered? This is the top email appearing at page number 33 of the judge's brief of document.
Exhibit?
This should be exhibit
F.
F. F থেকে হবে তো হ্যাঁ
Top, huh?
F. এটা পেন দিন আমাকে চট করে।
Exhibit F.
Shown the document appearing at page number 35 of the Judge's Brief of Document, Volume 1. Witness, kindly go through this document and tell this Honorable Court what is this document.
My lord, this document has been emailed by me on 14 September 2012 at 13:06 hours to defendant number 3, Mr. Umesh Singh, Indian agent of defendant number 1 and 2, informing them that most probably I will be meeting them at the airport.
Please go slow so that it can go down.
I will be meeting them at the airport.
What was the occasion for you to issue this email?
They were coming to me for discussion and finalization of the project.
What do you have to say regarding the contents of this document?
The content of this document is all true and correct.
How was this email issued?
This email was issued by my office computer, which I used to have in my custody, and I used for my email purpose on daily course of business.
Was this email, according to you, delivered to the defendant numbers 1 and 2?
Yes, my lord. This email has been defended to them as there is no bounce back intimation.
Mr. Witness, kindly look into the document once again and tell this Honorable Court whether the copy of this document has been marked to the defendant numbers 1 and 2.
This has been marked to defendant number 3, who is an Indian agent of defendant number 1 and 2.
Where is the original of this document?
This is the original document.
Did you offer inspection of the original to
Yes.
the defendant numbers 1 and 2, who are the appearing defendants?
Yes,
in
I
this
have offered
proceeding?
the inspection. Yes, we have offered the inspection
Lord, let this be tendered in evidence and marked as
of
exhibit
defendant number
G.
1 and 2.
23rd September. Shown. Sorry. Bolbo. Shown the document appearing at page 39 of the Judge's Brief of Document, Volume 1. Witness, kindly go through this document and tell this Honorable Court what is this document?
My lord, this document has been mailed by defendant number 1 to me, keeping defendant number 3 as in CC on 23rd September 2012 at 12:59 hours, stating that they cannot accept my counter offer and they have given their final proposed price.
Mr. Witness, can you just indicate before this Honorable Court what is the time difference between India and Korea, South Korea?
My lord, the time difference between India and South Korea is 3.5 hours.
Witness, can you just identify, having a look at the document, whether a copy of this has been issued to anyone else apart from you?
Already stated.
My lord, the copy of this email has been issued to me, keeping his Indian agent in CC.
Could you just encircle in blue ink the email address of the Indian agent of defendant numbers 1 and 2? Have you given any inspection of the original of this document to the defendant numbers 1 and 2?
Yes, my lord. The inspection has been offered to them and they have inspected it also.
Where is the original of this document?
These are the original documents, ma'am.
My lord, may this be marked, tendered and marked in evidence. This should go down as Exhibit H.
My lord.
Next, shown page number 40 within bracket middle of the judge's brief of document volume 1. টা হলো লাস্ট কোনটা হলো কোন মেলটা
लास्ट मेल डेट क्या है बताओ
23rd হয়েছে
HHH
last yes let him answer
What is the question?
Shown page 40 middle of judge's brief from volume 1. Witness, kindly tell this honorable court what is this document?
My lord, this document has been sent by me to defendant number 1 and defendant number 3, his Indian agent, stating that I am not available and will reply his mail after 10 days.
What was the occasion for you to send this email?
The occasion was to send this email was in respect of their email dated 23rd September 2012 at 12:59 hours, where they were stating that they are not able to accept my counter offer against their proposed price.
How have you issued this email?
This email has been issued by my office computer, which was under my custody and which I used to email on my daily course of business.
What do you have to say regarding the contents of this email?
All the content of this email are true and correct.
Have you offered inspection of the original to the defendant numbers 1 and 2?
Yes, my lord. The inspection has been offered to them and they have taken the inspection as well.
My lord, let this be tendered and marked as Exhibit I. Next to 8th November. Page 82. Shown page 82 within bracket bottom of Judge's Brief of Documents, Volume 1. Witness, can you tell this honorable court what is this document appearing at the bottom of the page?
My lord, this mail has been issued by them on 8 November 2012 at 9:18 hours.
Just ask him to wait once. The second page of that document has come out. Original second page. Yes, please continue.
My lord, this document has been emailed by me on 12th November 2012 at 11:51 hours to defendant number 1 and defendant number 3, the Indian agent of the company, stating and
My lord, there is some confusion. I am showing you page number 82 of the judge's brief of document. Please simultaneously look at the judge's brief of document. The bottom of that page, page number 82 of the judge's brief, volume 1. And the original of
You are having the page 82. Show the page 82 of the GBD.
একবার দেখো। হ্যাঁ 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 please দেখি। অরিজিনাল যেটা দেওয়া হয়েছে ওটা কি সেম ডেট না গড়বড় হয়ে গেছে?
And you now see the other document, which is loose document. That is the same document?
Yes.
What you have written? That is there?
No, sir.
No.
No.
No, my lord.
So
No, my lord. In this document, it is there.
Just a minute, just a minute.
Answer to
The first answer, tha na? You delete it. The question was there. What is the question? Yes, now give answer.
My lord, this document has been issued by defendant number 1 to me on 8 November 2012 at 9:18 hours. This document contains the offer of the printing machine, and they were justifying it with other companies' machine cost.
Have you given inspection of the original of this document?
Yes, my lord, the inspection has been offered and inspection has been taken by the defendant number 1 and 2.
Where is the original of this document?
This is the original document.
My lord, let this be tendered and marked as exhibit.
IJ.
J. J হলো। পরেরটা কোথায়? 12 নভেম্বরের আগে আরেকটা এই থামবে। আরেকটা আছে। Witness, kindly come to Judge's Brief of Documents, page 83, bottom. Just ওনাকে Judge's Briefটা দিন। Can you please tell this honorable court what is this document?
My lord, this document has been emailed by me to defendant number 1 on 8th of November 2012 at 13:51 hours, and the content is just regarding the bargain of the cost of the machines, which I have to procure from them.
Witness, have you given the inspection of the original of this document to the defendants?
Yes, my lord. The inspection has been offered and given to defendant number 1 and 2, and they have already done the inspection.
Where is the original of this document?
This is the original document, my lord.
Which one? I'll put a different question.
Even the other documents also, it cannot be said it is original. It is the
They are the
copy downloaded.
yes, no, these are all taken fresh, but
Downloaded from
the
the-
printer is not. It's all black and white, so
It is
that is why
downloaded.
there was a need for filing of 65B, which is also complied. I'll put the question to him because that affidavit has also been tendered.
Okay.
Witness, have you filed any affidavit under the Evidence Act before this honorable court with regard to the documents disclosed by the plaintiff in the instant proceedings?
Yes, my lord, it has been filed, but those documents are already filed earlier as well for the proceedings of this particular case.
What do you have to say regarding the contents of this email dated 8th November 2012, which you say to have been issued by you at 13:51 hours?
My lord, all the content of this email are true and correct.
My lord, may I be permitted to have this tendered and marked as exhibit?
That's hard copy. Huh?
হ্যাঁ পরের পাতায় আছে
No, okay.
Let an order be recorded at the end. I'm keeping a tab of all the documents which are being marked as exhibit, apart from the ones which are provided separately.
Other document is exhibited here.
No, others are given to him separately. For some reason, my advocate on record has missed out with regard to this one. I'm keeping a track of this. Then I'll indicate to your lordship when your lordship dictates the order. लिखे रखो एक जगह 8th November 2012 page 83 bottom tendered at
एक काम करो इसको
exhibit
मार्क करके
এটা নিচ্ছি
ये तो जेरॉक्स होगा, जेरॉक्स तो नहीं होगा। मार्क करके पुट इट मार्क।
দেখো তো এইটা ট্যালি করছে কি না
Which portion? Down portion? No, sure. Which portion?
Bottom portion. Exhibit G1.
K.
No, not top. Down portion.
Bottom. ট্যালি করছে চেক করেছো?
Yes.
হয়ে গেছে তো? হ্যাঁ 8th November 2012 টাইমটা লিখে নিন কারণ দুটো ডেট আছে একই 8th November 2012 at 13:51 hours. Shown the document appearing at page number 93 of the Judge's Brief of Document, Volume 1, 93 within bracket bottom.
Yes, what is the question?
What do you have to say regarding the document?
My lord, this document has been mailed by me to defendant number 1 and defendant number 3, the Indian agent of the defendant number 1, on 12th of November 2012 at 11:51 hours, and the content is about the treatment level and machine which is required for this project.
How was this email sent by you?
This email has been sent by my office computer, which was in my custody, and I used to mail for my daily course of business.
Mr. Witness, can you just tell this honorable court whether there was a delivery failure of this particular email in your mailbox?
My lord, there was no delivery failure as there is no such intimation in my mailbox.
What do you have to say regarding the contents of this document?
My lord, the content of these documents are all true and correct.
Where is the original of this document?
This is the original document.
Have you offered inspection of this document, the original of this document, to the defendant numbers 1 and 2?
Yes, the inspection has been offered to defendant number 1 and 2, and they already inspected it.
My lord, let this be tendered in evidence and marked as Exhibit
L.
L. এবার হচ্ছে number. Shown the document appearing at page number 112 bottom of the judge's brief of document, volume 1. One 112 bottom and 113 করে দিন এটার পরে আমি যে অরিজিনাল দিলাম না এখনই দিন ঠিক আছে স্টার্ট Witness, kindly tell this honorable court what is this document?
My lord, this document has been mailed by me to defendant number 1 and 3 on 19th November 2012 at 15.04 hours, and the content of the mail is on the discussion of number of advance installments.
Witness, can you identify the mail ID of defendant number 1 and 2
Yes.
in this email?
Yes, my lord.
Please encircle the mail ID of defendant number 1 and 2 with red ink. Witness, can you now identify the mail ID of the defendant number 3? Please have it encircled with blue ink. Huh? আর ওটা
blue ink.
blue ink দুটো আলাদা করো
Defendant number 3 blue ink.
Now, how was this mail sent by you?
My lord, this mail was sent by my office computer, which I use for emailing during my daily course of business.
Mr. Witness, did you have any intimation in your mailbox regarding the failure of delivery of this mail ID, either on account of defendant numbers 1 and 2 or defendant number 3?
My lord, there is no such intimation of mail bounce back of any of the either defendants number 1, 2, and 3.
Where is, sorry, just delete that portion. Have you offered inspection of the original of this email, which is appearing at the bottom of page number 112 of the judge's brief of documents, volume 1?
Yes, my lord. Inspection has been offered to defendant number 1 and 2, and the same has been taken by them.
My lord, let this be tendered in evidence and marked as Exhibit M. Paper affidavit on evidence to the for volume. আচ্ছা এবার একটা স্পাইরাল ভলিউম আছে ওই স্পাইরাল ভলিউমটা দিন হ্যাঁ আমি পেয়েছি তোমাদের কাছে নিচে shown page number 65 of the affidavit on evidence of PW1 within bracket লিখে দিন documents annexed to the affidavit on evidence. Confusion হবে না হ্যাঁ স্পাইরাল Witness, kindly go through the last document appearing at page number 65 and tell this honorable court what is this document?
My lord, this document has been emailed to me by defendant number 3, an Indian agent of defendant number 1 and 2, on 7th of February 2013 at 12:04 hours, and the mail has one attachment giving me the load factor which will be required for the plant and machinery which were supposed to be supplied by them.
Witness, can you just indicate whether it is for the first time in your affidavit on evidence that you have disclosed this email?
No, my lord. This evidence has already been submitted earlier as well for the proceedings of this case to my advocate.
Shown page number 53, or rather serial number 53 of the additional disclosure made by the plaintiff by way of covering letter dated April 15, 2024. Witness, can you just compare the bottom of this document that I'm showing you with the one which is disclosed at page number 65 of the documents along with your affidavit on evidence, and tell this honorable court whether this is the same document? My lord, this is necessary by I'll indicate a point has been taken on the earlier occasion by my learned senior friend that these documents have been disclosed for the first time. So I'm trying to correlate and I'm trying to get it through the witness so that it is also taken on record. And
why the confusion occurred? Because if my lord takes the additional documents, the page numbers are not like this. It is 51, 52, 53,
yes, but
then 54.
these were
That
all
is the
indicated
reason.
in the serial in the column itself.
So there is a
in
confusion.
the context.
She said she'll clarify.
Next. Yes, what is your answer?
Ma'am, could you just put the question again because it's not my.
Try to repeat
question, repeat.
Can you just compare the bottom of each document? By case number 6 of the document of evidence has yet to come to court, whether the same document.
I have asked you to compare between the two documents and tell this honorable court whether they are the same and identical or not.
Yes, my lord. These both the documents are same and identical.
Next. Shown page number 66 of the affidavit on evidence within bracket documents করে দিন। Page number কি বললাম 66 bottom করে দিন bottom হ্যাঁ এভিডেন্স এর bottom হচ্ছে না এটা মিডল হচ্ছে Please tell the Honorable Court whether this is the document which has been disclosed by you in your affidavit on evidence for the first time in this proceeding.
My lord, this has been already submitted earlier as well for the proceedings of this case. This is not for the first time.
Shown serial number 58 of the additional documents. ওই যেটা আগের ভলিউমটা দিলাম আমার হাত থেকে দিয়ে দিয়েছি কম্পেয়ার করার জন্য যেটা দিলাম serial number 58
serial number 1 2 3 down
page 58 serial number 58 yes 58 মেশিন নাম্বার আছে একটা আমরা দিন আমি বার করে দিচ্ছি Okay, let me put the question to him. He'll clarify if I. No, original China. There is a confusion. Oh. Sorry. It should be serial number 59, not 58. No, means 20th. There is a confusion. Just skip the question in both the two last questions. There is some confusion regarding the pagination. I'll not put this question to him.
It has to be deleted.
Yes, because I can't correlate. There's some
Delete.
mistake in my writing.
Question delete.
Question last duto question deleted. I mean compare kortam, but it's okay. Shown page number 71 of the affidavit on evidence. Witness kindly look at the document and tell this honorable court whether this has been disclosed for the first time in this proceeding.
My lord, no, this is not the first time. This document has been already been disclosed earlier for the proceedings of this case.
Yes, next.
Yes. Shown page number 112 of the additional disclosure dated April 15, 2024. Witness kindly compare the two documents and tell this honorable court whether it's the same email or not.
Yes, my lord, these both the documents are same and identical.
Now witness kindly turn to page number 112 of the affidavit on evidence within bracket documents and tell this honorable court whether this is the document which has been disclosed for the first time in this proceeding by way of your affidavit on evidence.
No, my lord, this is not the first time. This document has been already been submitted earlier.
Kindly compare this document with page number 112 of the additional disclosure and tell this honorable court whether it's the one and the same document.
Page number change.
Page number
112, same page.
of the same page
Yes, same page.
of your
Not the
JPD
case.
also.
Then there's 112A also he can look into. This is dated 26 March 2013. Please compare the contents of the two emails and tell this honorable court whether they are one and the same.
Yes, my lord. These both the documents are same and identical.
Shown, next question. Page number 70 of the affidavit on evidence within bracket documents. Witness, kindly tell this honorable court whether this is disclosed by you for the first time in this proceeding by way of your affidavit on evidence.
No, my lord, this is not the first time I am disclosing it. This document has been already disclosed earlier as well.
Witness, can you identify this document by comparing it with pages 112 and 112A of the additional disclosure and tell this honorable court whether you can find the copy of the same earlier disclosed in this proceedings.
Yes, my lord, both the documents are same and identical.
Shown page 122 and 123 of the affidavit on evidence within bracket documents. Witness, kindly tell this honorable court whether this has been disclosed by you for the first time by way of your affidavit on evidence.
No, my lord, this is not the first time I have submitted this document. It has been already been submitted earlier as well.
Shown page 193 of the Judge's Brief of Documents, Volume 1. Witness, kindly compare the middle of page number. Judge's Brief. Oh, sorry. The middle of page number 193 of the Judge's Brief of Documents, Volume 1, with the page numbers 122 and 123, and tell this honorable court whether this is the same document that is appearing at the bottom of page number 122 in this proceeding. 122 bottom. 193 সাথে 122 তলা আর 123 top.
এটা ম্যাচ করছে।
হ্যাঁ বলুন যা বলার। Please answer.
Yes.
Yes, my lord, it is matching both the documents. are same and identical.
Witnesses shown, pages 15 and 16, within bracket documents, annexed to the affidavit on evidence of PW1.
Yes, that one.
15, 16. Witness, can you tell this honorable court whether this document has been disclosed by you for the first time?
No, my lord. This document also has been submitted earlier. This is not for the first time.
Shown, page number 217 of the plaint. Plaint একটাই volume কিন্তু মোটা volume. Page 217 bottom লিখে দিন of the plaint. Witness, can you compare the two documents and tell this honorable court whether they are one and identical?
Yes, my lord. Both are same and identical.
Shown, page number 81, within bracket documents, annexed to the affidavit on evidence of PW1. Page 81. Witness, kindly tell this honorable court whether this document has been disclosed by you for the first time in your affidavit.
No, my lord. This document has been already submitted earlier as well. This is not for the first time.
15th May. Now, I'm drawing your reference to the bottom of page number 81, which is an email issued by Urmesh Singh to defendant number 1 with a copy marked to the plaintiff. Have you been able to identify the document?
Yes, my lord.
Now, please compare the same with page number 75 of the additional disclosures. ওটা ওখানে আছে. And tell this honorable court whether bottom of page 81, within bracket documents, disclosed along with the affidavit on evidence of PW1, is the same document which is also appearing at page number 75 of the additional disclosures.
Yes, my lord. Both the documents are same and identical.
Shown, page number 81, second document, which is an email issued by the plaintiff to the defendant number 3. Witness, full stop report. Witness, can you please tell this honorable court whether this has been disclosed for the first time in your affidavit?
No, my lord. This has been already disclosed earlier. This is not for the first time.
Witness, kindly compare this document along with the document appearing at page number 75 of the additional disclosures and tell this honorable court whether you can find the same document appearing in the additional document as well.
Yes, my lord. Both the documents are same and identical.
Shown, page 143 and 144, within bracket documents, disclosed along with the affidavit on evidence filed by PW1. Witness, kindly go through this document and tell this honorable court whether this has been disclosed by you for the first time.
No, my lord. This document also has been disclosed earlier. This is not for the first time.
Witness, kindly now compare this with the additional disclosure, page 79, and tell this honorable court whether you can locate this document in the additional disclosure as well.
Yes, my lord, both the documents are same and identical.
Shown page number 172 of the documents disclosed along with the affidavit on evidence of PW1. The email dated 2nd July 2013. Full stop. Witness, can you tell this honorable court whether you have disclosed this for the first time in your affidavit on evidence?
No, my lord. This document was already submitted earlier. This is not for the first time.
Witness, kindly compare this with page number 95 of the additional disclosures and tell this honorable court whether you can find this document in the additional disclosures as well.
Yes, my lord. Both the documents are same and identical.
Shown page 197 to 199 within bracket documents disclosed along with the affidavit on evidence of PW1. 197 to 199, which is forming part of the email dated 19th November 2013. The date is appearing at page number 198 of your affidavit on evidence, the documents. One which continues from 197 to 199. Witness, can you tell this honorable court whether this has come for the first time in your affidavit?
No, my lord. This was also submitted earlier. This is also not for the first time.
Witness, kindly go through pages 101, capital D, comma, capital E and capital F of additional disclosures and tell this honorable court whether you can identify this document from the additional disclosures as well. JBD volume 2.
Yes, my lord. Both the documents are same and identical.
Shown page number 199A and 199B of the documents disclosed along with the affidavit on evidence of PW1. Witness, kindly indicate whether this has been disclosed for the first time on your affidavit.
No, my lord. This document is also not for the first time. It has been submitted earlier as well.
Witness.
Yeah, no, take the last. I will close this.
Yes, this is the last question only. I am done with the chief.
Okay.
I have only put questions with regard to the documents where the existence were in question. Those I have gotten exhibited, and regarding the difficulty with regard to the other documents, I have asked him also, and he has clarified. So only one question. Last question. Yes, I'm looking at the watch also. By the watch, page number. Please compare this document along with page number 380 of JBD volume 2, Judge's Brief of Documents volume 2, and tell this honorable court whether this is the same document which is appearing at pages 199A and 199B of your documents disclosed along with your affidavit on evidence.
Yes, my lord. Both the documents are same and identical.
My lord, so far as the examination in chief is concerned, it can be closed. Yes, I had done it before. Only these were left out. এটা আমার না এটা তোমার এটা এসসিজি
So and so offering for the plaintiff.
আমার দুটো বলো
So and so offering for the defendant. Plaintiff witness is present and the examination chief resumed. During his examination, how many documents have you? Documents were exhibited being exhibit A to F2M. F2M. Full stop. Counsel for the plaintiff permitted. Examination chief is concluded. Full stop. It is find that the examination chief of this witness
yes
is the Amit Agrawal.
yes your lordship
This witness, namely Amit Agrawal, was recorded on 31st of January 2025. And in question number 7, he has, no, question number 6, he has stated about the board resolution. And the same was identified and marked as exhibit board resolution. But board resolution full stop. The board resolution is marked as exhibit A, but in the deposition it has not recorded. Accordingly, in question number 6 of this witness dated 31st of January 2025, it may be added the board resolution dated 1st March 2014 be marked as exhibit A. Marked as exhibit A.
grateful to lodge and one other document was also marked that is also marked.
Manutosh,
8 November there was one document.
The resolution dated is marked as exhibit A. यहाँ में आएगा. Let the कल fix नहीं है ना? Let the matter appear on when?
My lord, now it's the
Cross-examination.
examination which has to happen.
Matter appear on 18 July at 11:30. 11:30 for
Grateful to
cross-examination.
Grateful to lodge. 18th July.
18th, not 8.
Grateful to.
Yes, call the next matter.
And I'll continue.
Yes.
And item number 3 is the disposed of suit. It's only there for the records. It's not.
What is your name, sir?
Sandeep Sethia.
Sandeep Shetty. Spelling?
Resume, huh? Examination chief resume.
DWP.
Question কত থেকে বলো তো?
বলছে 108 পরিংটা পরে হয় actually.
Do you recall when RK Agencies Limited first asked for refund of the fixed deposit?
Yes, on 28th of May, 1985.
As on that date, what would have been the value of the fixed deposit?
20 lakhs and 60,000 rupees.
Did RK Agencies Limited ever apply to the Reserve Bank of India for permission to transmit the said proceeds to any foreigner's account?
No, it did not.
Do you know whether the plaintiff bank ever applied for such permission to the Reserve Bank for transmitting the money to a foreigner's account?
Yes, the plaintiff applied to the Reserve Bank of India on 29th of November 1985 to transmit the money to its London branch to set off its claim
London branch.
to set off
its claim against SL Setia Liners Limited
Is SL Setia Liners Limited.
only.
Do you know whether the Reserve Bank of India granted such permission to the bank?
The Reserve Bank of India denied the permission on 14th of January 1986.
You had spoken earlier, Mr. Setia, of the blocking of the account by Reserve Bank of India. Can you tell my lord when such order was passed?
On the 5th of September 1986.
Who disclosed? Now, is there any document to show the Reserve Bank of India had blocked or frozen the account?
Yes, there was a letter from the Exchange Control Department to the bank. It is disclosed. Is A14.
Okay. A15, sorry.
15.
Has this letter been disclosed in the proceedings?
Yes, it has.
Page 31. Please have a look at the document marked Exhibit A15 at page 31 of the judge's brief of the documents, volume 1.
Mm-hmm.
Is this the document you are referring to?
Yes, it is.
What is your understanding of this document?
The letter from the RBI directs the bank not to close or transfer the fixed deposit account. It does not prevent the bank from using the money to earn profit in the usual course of banking.
Deblocking. How long was this instruction of the Reserve Bank in force?
Until 23rd of July 2006 or thereabouts. 2006 or thereabouts.
No. Is there any document on record to show this?
Yes.
No, to show this.
Yes, the Reserve Bank of India wrote to the bank and to RK, to the lawyers, to the advocate of RK Agencies Limited to confirm that this had been done.
A5 लिखा है blocking letter A15 होगा. No, this is not. Anyway, that's it. Now, during the period between when you asked for refund in May 1985 till the deblocking of the order, as it were. No, I'm still the blocking. I'm sorry, till the blocking of the account, as it were, on when did we say that? September 1986. Was there any impediment for the bank to return the money to the plaintiff, to RK Agencies Limited?
There was no injunction from the RBI. There was no impediment. There was no impediment.
Did the bank maintain the FD during this period?
The bank did not maintain the FD. It did not accrue interest or do anything that would indicate that it had maintained the FD. That would indicate that it had maintained the FD.
What, according to you, did the bank do with the proceeds of the FD after May 1985?
I think it simply took it. Simply took the money.
Now, your answer is wrong. It's calculation. No. In answer to question, my lord will give me 1 minute. It is obviously wrong. In answer to a previous question, you have mentioned that the calculation of interest shown by the bank to the tune of approximately 89 lakhs as on August 9, 2006 was, inverted commas, wrong. Why do you say that? Why did you say that? Well, I'll give the question number. You said it. I just said.
The bank has disclosed the historic data of its interest rates up to 2006. And it has also disclosed its computation of the interest.
Yes.
The historic data of interest rates is much higher than the data applied by the bank. Than the interest rates applied by the bank.
I am showing you a document which has been marked as Exhibit 6. The printout. Is this one of the documents you are referring to in your previous answer?
Yes, it is.
What is this document?
This document is a record of interest rates on savings, deposits, and loans as maintained by the RBI over a period of time.
Who has disclosed this document
in
this proceeding?
The plaintiff has disclosed this document.
Do you have any idea of the lending rates applied by the bank during this period mentioned in this document?
In my experience, and the plaintiff has also confirmed that the prime lending rate or the base lending rate or whatever is prevailing plus 4% would be quite usual.
What, according to you, would be the interest earned by the bank from May 1985 on your fixed deposit of 20,60,000?
In 2017, at the time of filing the counterclaim, the computation exceeded 40 crore rupees. Today, it is well in excess of 100 crore rupees. 40 years have passed on the 28th of May 2025.
Well, with your lordship's leave, may I ask him that if he can produce a calculation? So just the math, or I can do it during argument also. We can do it in the arguments because let him give his version of the
Produce at the time of argument, no problem.
Very
Corroborating the evidence.
Now, Mr. Setia, the plaintiff has relied on two letters written by one Zaiwala, Z-A-I-W-A-L-L, Zaiwala and Company. Did RK Agencies Limited have any connection with such Zaiwala and Company?
No.
I am showing you Exhibit A5, brackets on page 9 to 11 of the judge's brief of documents. And Exhibit A7, pages 14 to 16 of the judge's brief of documents. Can you tell my lord what these documents are?
So the first letter is dated 11th of February, 1985, from Zaiwala and Company to Messrs. Stockin and Lambert, the Lambert, L-A-M-B-E-R-T, the solicitors of the bank. Zaiwala says that he represents S.L. Sethia Liners and another in a suit filed by the bank. From the records, we know that the other party was K.C. Sethia, brackets 1944, close brackets, Limited. To begin with, Zaiwala denies the claim of the bank against S.L. Sethia Liners Limited. Later in the letter, Zaiwala reminds the bank of some possible agreement between the bank and S.L. Sethia Liners Limited to prospectively use money expected to be received from RK Agencies Limited to reach a settlement of the bank's disputed claim against S.L. Sethia Liners Limited. That's the first letter. The second letter is dated 4th of July, 1985. This is addressed to Simmons and Simmons, who are also the solicitors of the bank. It refers to a letter dated 29th of May 1985, written by Stockin and Lambert in reply to the earlier letter. The bank has not disclosed that letter. But later in his letter, Zaiwala makes reference to it. The bank has denied any agreement to use the money of RK Agencies Limited to settle its claim against S.L. Sethia Liners Limited. It's already on the record. It was quoted earlier. But he says, with regard to the deposit of 2 million rupees with your client's Calcutta branch, our clients are simply appalled that your clients should plead ignorance of the fact that these monies were deposited on our client's behalf. And he says that he will be filing a defense and counterclaim at the end of that letter. A defense and counterclaim to the suit of the bank in the last paragraph of that letter. I might add, in case I haven't said it already, Zaiwala was not speaking on behalf of RK Agencies Limited. He was speaking on behalf of SL Setia Liners Limited.
SL Setia Line Limited.
Despite relying on these two letters, what is the bank's stand in the present suit relating to the fixed deposit?
The bank's stand is completely the opposite of what these letters seem to suggest. The bank's claim is that it had an agreement with RK Agencies Limited for use of this money to pay its decretal claim against SL Setia Liners Limited. It has now retracted the decretal part of that claim. It now claim. It's no longer saying it was a decretal claim after 30 years.
Now, please have a look at exhibit A by 8 at page 17 to 18 of the judge's brief of documents. Can you say what this document is?
This is a letter written by Simmons and Simmons, solicitors of the bank, to their client, the bank, dated 30th of May, 1986. It's not clear on this document, but there is a cleaner copy of it elsewhere in the judge's brief of documents. 30th of May, 1986.
It's clear.
It says that Zaiwala and Company have withdrawn any claim against the bank for the fixed deposit lying in India in their counterclaim against the bank. And it updates the bank on the progress of its suit.
Now, are you aware whether this suit referred to in all these three letters I have just shown you, namely Central Bank of India versus SL Setia Liners Limited and another, and KC Setia 1944 Limited, was decreed? Are you প্রশ্নটা করে দেবেন? হ্যাঁ, ঠিক আছে।
Yes.
Well, it is 38 years since we filed suit, and the bank claimed for the longest time that it was decreed, but it has not produced so much as a photocopy of this alleged decree.
Do you know whether there is a decree against SL Setia Liners in favor of the Central Bank of India in the UK?
It's pretty certain that there was no decree. I believe at some point, yes, in the memorandum to the board resolution, the decree, no decree is mentioned. And at some stage, it was alleged that the company went into liquidation and no decree was obtained.
In any of these letters, was Drum Place Limited mentioned?
No.
Did the Central Bank of India refer to any decree against Drum Place during the course of the 1987 suit?
Yes. It introduced Drum Place for the first time when it filed its affidavit in opposition in 1987. By that time, as we now know, the bank had not only obtained a decree, it had executed it in 1985, and the company had been wound up, and the claim had been written off.
Was any decree or copy of a decree produced before any of the courts in the 1987 suit?
A copy of the decree against Drum Place Limited was produced before the court in 1990 under cover of a letter of Simmons and Simmons, who had acted for the bank to wind up Drum Place Limited.
Was any certified copy of the decree ever produced by the bank?
No.
Are you aware of any enforcement proceedings for execution of this foreign decree in India against either RK Agencies Limited or any other person?
I'm not aware of any such proceedings.
Is it the bank's case that the money was appropriated against the decretal dues of Drum Place Limited in this suit?
The bank's case has been changing at every occasion. On the final day of hearing of the appeal before the division bench, the counsel for the bank appeared in court with a copy of the decree on which he had not relied till date. He claimed to have just discovered the decree and demanded that the bank be given opportunity to try and enforce it. And that is why the judgment of the division bench granted a stay on execution of the decree in favor of RK Agencies Limited.
After obtaining the stay, did the bank pursue the enforcement of the decree against against Drum Place Limited?
No, it abandoned that story immediately. No, full stop. It abandoned the story immediately. It filed an SLP before the Supreme Court, which did not rely on any claim against Drum Place Limited.
I'm drawing your attention to Exhibit 1/8, 1/18 at page 26 to 37 of the second additional judge's brief of document.
Yes.
Is this the document you are referring to?
This is the first page of the SLP.
Can you tell my lord what was the stand of the bank relating to adjustment of the FD before the Supreme Court of India?
Well, the first paragraph captures it quite well. It says the present petition is limited to the question whether the petitioner bank's right to set off or adjust the deposit lying with it towards the outstanding debts is contingent upon the permission of the Reserve Bank of India. Permission of the Reserve Bank of India. There were other stands taken by the bank in the SLP. I think there were about 22 grounds for the SLP. But primarily, the bank was claiming it had a right to unilaterally appropriate the fixed deposit of RK Agencies Limited towards a decretal debt, still a decretal debt, of SL Sethi Liners Limited.
In this SLP, did the bank refer to or insist upon enforcement of a decree of Drum Place Limited?
No.
I'm drawing your attention to Exhibit 1/19, which is already on record, from pages 38 to 74. 38 to 74 of the second additional judge's brief of documents. Can you tell my lord what is this document?
RK Agencies had also filed an SLP before the Supreme Court for being aggrieved about the quantum of interest in the decree that it had received. This was the bank's reply to that SLP.
Can you tell my lord can you tell my lord, from a perusal of the document, what is the stand taken by the bank as far as the decrees against, as far as the alleged decrees?
So, paragraph 4A of this affidavit on page 43 is quite clear. It says that Messrs. Drum Place Limited and Messrs. SL Sethi Liners Limited, both belonging to the House of Sethi group of companies, jointly owed a sum of ... to the bank. The respondent bank had taken civil action against both the companies in the English courts, in addition to filing criminal complaint against Messrs. Drum Place Limited. I state that in the year 1984 to 1985, the suits against both Drum Place Limited and SL Sethi Liners Limited were decreed in the respondent bank's favor, and during the execution proceedings, Drum Place Limited was ordered to be wound up.
What do you say about the statement that there was a decree against SL Sethi Liners Limited? About the statement made by the bank in its affidavit that there was a decree against SL Sethi Liners Limited.
It seems very clear that the bank was always aware that it had no decree against SL Setia Liners Limited and was only litigating to delay refund of the money to RK Agencies Limited.
The 33 and 34, DD 33. Mr. Setia, were you personally present during the Supreme Court hearings of the 1987 suit?
I was.
Do you recall how many days the matter was heard?
It was heard on 2 dates.
35. I'm showing you, I'll show it from here. A document disclosed by the defendant in this suit being DD 35 at page 145 to 147 of the first judge's brief of documents. 145. He's given you a clear copy. And also drawing your attention to another document being DD 34 disclosed at page 144 of the judge's brief of document, volume 1. Can you tell my lord what these two documents are?
Okay.
Vegetable.
The first of these documents is a letter written by the bank to the Reserve Bank of India. The copy in the judge's brief of documents is illegible. But I believe we have a clean copy, a legible copy.
Yes.
After the first hearing in the Supreme Court on the 26th of September, 2016, the bank wrote to the RBI as directed by the Supreme Court to give their opinion in relation to the proceedings. It was a short letter. It didn't say much else. The other letter, DD 34, is the bank's reply, the Reserve Bank's reply to the bank, dated 19th of October, 2016. On the 10th of March, 2017, on the second hearing, the bank produced this letter before their lordships, and their lordships were pleased to dismiss the SLP of the bank.
How did you obtain a copy of the document marked DD 34?
Well, a copy of this was handed over to our advocates in the Supreme Court.
How did you obtain the document disclosed as DD 35?
From the reference given in DD 34, our advocates wrote to the RBI under the Right to Information Act and obtained a copy of the earlier letter.
Who was your advocate?
Mr. U.S. Menon.
No. ঠিক আছে। I'm showing you a document. Can you tell my lord what this document is? And it's just a legible copy of this.
This is a copy of the right to information application to the Reserve Bank of India, or an acknowledgement of it, and a copy of the letter written by the Central Bank of India on 30th of September 2016 to the Reserve Bank of India.
Is this the document disclosed as DD 35?
Yes, it is.
Well, may that be marked as exhibit.
It's not
Already there.
No,
The document is not there.
no document. These two documents were not marked officially. It's there. The bank's letter. They're not originals. The bank has given a letter to Reserve Bank.
Their client.
They produced it.
It's written to their
Yes.
advocate.
It was not disclosed.
No, it's disclosed.
Disclosed, but it's being
The-
exhibited.
The document that
Exhibited.
no, now I'm
You're objecting.
Well, the page one, the last page is 147 because the judge's brief, it's completely illegible. That's the central bank's letter
Okay.
itself. The central bank asked the Reserve Bank a question and they produced the other letter. So these are matters of record.
All I want to say is this, my lord, a letter has been written by the Reserve Bank of India to my learned friend client's advocate. So, my lord, he must be having the original, or he must have to give the reasons why he is wanting to put in secondary evidence.
No, it is addressed to you.
U.S. Menon is his advocate.
No, this letter.
No, that is the RTI letter.
Last
The main letter is their letter.
Last letter.
No, that is central bank's letter itself.
Correct.
Not one, but 145.
No, that's
And
the cover.
the RTI letter.
Yes,
RTI.
that is the one I'm objecting to.
No, it is
Central Bank.
And this central bank, this one.
DD 34, my lord, one page prior to that.
Reply করেছে তো Mr. Menon. এটা তো original
This is addressed to us. 145 is addressed to my learned friend. I'm objecting to this.
These two. Exhibit
145 and 146.
And we shall try to produce the original.
Page 144 and 145 are marked as exhibit 16 with objection.
No,
and page
144 is 16. That is not objected to. 145 to 147 is objected to.
Judges brief. Will kindly have a look at the page numbers from the judges brief.
Yes.
145 and 146.
Yes.
145, 146
is objected to.
with objection. And 140?
140, the previous one. 144 is not objected. So that's addressed.
144, then I'll mark as exhibit 16.
No, 144 is not here.
No,
Yeah.
that's the reason I handed up the.
That is already being
144 is not there. 145, 146 and 147.
147 is there.
147.
Yes. Enclosure. No, that's purported
is
to be
your
an
right.
enclosure. Because the original come by Leonard says.
145, 146, 147 marked as exhibit 16 with the objection.
Subject to
And Malad, the DD 34, which is not objected to, can be marked on the judge's brief.
Which one?
That is that 144. I have asked him both the questions. That's the document produced in court.
That is your letter. That is your letter.
141.
My learned friend is objecting to the
Document
photocopy.
Being DD
DD 34.
34 is marked as exhibit
17.
17.
We are objecting
Well,
to
I
DD
might
35.
take another 15 minutes on 15th. Your lordship gives me that 15th or 16th. 16th, 17th, 18th is there. So I'll finish on the 16th. My learned friend can begin on 17th. I'll just have the like
15, 16, 17.
yes.
DD
July.
35 to
Yes.
objection. That's
It's already there. But I was hoping I'll finish my chief and my learned friend will begin.
15,
But
16 July क्या बजे? 12:30. So plaintiff.
their position
Defendant witness is present. Examination chief resume.
কবে আসছিস আমার সঙ্গে বসতে?
Two documents may mark as exhibit
এটাকে নিয়ে নাও।
16 and 17.
My
16 with the objection. 17. Examination chief could not be completed due to paucity of time. Accordingly, is let the matter appear, and it is submitted that the matter is already fixed on 15th of July 2016. 15 nahi hai. 16 of July 2025. Let the matter appear on 16 July at 12:30. 12:30 to?
Great. Ablash.
এই আমাকে না এই রোলটা
department insists to take leave, my lord.
Short cost, why short cost title?
Well, this is a BIFR matter in company matter. I want to file application on behalf of the Shramik Union and one secure creditor to disburse the amount from the company in liquidation. So, my lord,
who is for the other liquidator?
But I have not served at case. Now I will file and I will serve.
My lord, I am also faced with a similar issue.
Leave,
Mine is
leave
also
is
an
granted to file the same with the short cost title.
My lord, I am also faced with a similar issue. This is an application in a company which is in liquidation. I am for also a creditor. However, since I do not have the copy of the main application, so
okay, that also grant.
Grateful, my lord.
Great. New grant.
May I seek your lordship's kind leave to mention a matter, your lordship. This is for obtaining your lordship's leave for obtaining the certified copy of an order. It's a 1987 order. The situation is a little quaint, if I may put it that way. We applied before the department for obtaining the certified copy of this order. The department says that this order had already been supplied to the previous advocate on record. After that, there was a change in advocate on record, and the present advocate on record has been filing the request for obtaining the copy. Now, your lordship, the department says that it requires your lordship's kind leave for obtaining that copy.
Which order?
It's a 1987 order, your lordship.
Company matter?
Company matter. Company petition 226 of 1997.
So you're not filed the wakalatnama. Where is your wakalatnama?
Your lordship, the wakalatnama, my instructions are it's yet to be filed, but your lordship, the certified
without the wakalatnama, how you can get the certified copy?
No, your lordship,
that is a pending matter.
It is not a
pending.
It is not a pending matter. Your lordship, I have obtained instructions on this count. It's disposed of. This is actually, your lordship, regarding modification of a 1987 order.
Oh. It is not recorded.
Your lordship, for a disposed of matter, wakalatnama being I'm extremely grateful to your lordship.
My lord, I am praying for inclusion of an old company matter, my lord, CP number 219 of 1973, my lord.
23, it is still lying.
Yes, my lord.
It is not transferred to the.
Not yet, my lord. I am praying for inclusion in the list, my lord.
For what?
Company has, my lord, 3,800 shares of Kilojan Tea Company Limited.
300?
3,800 shares
3,800
of Kilojan. I think only these assets are there. And official liquidator wants to sell also. And my lord, my clients are employees of Kilojan Tea Company Limited. They want to purchase also, of course, the highest, if they have highest bid, my lord. So that, my lord, this
Whether auction process was done or not?
No, not yet, my lord.
How you can purchase?
Then, my lord, therefore, my lord, so that the thing is expedited,
Okay.
my lord.
Put it.
And it was earlier it was appearing in the list.
Yes.
Mentioning item number 60, my lord, last occasion, your lordship, remember the landed valuer, my lord, who was standing behind your lordship, my lord, your lordship indicated me that next week, my lord, your lordship, this matter can be mentioned so that it can be taken up. My lord, the valuer is the person.
So what is the matter?
My lord, that is with regard to the, my lord, the sale, the valuation and my lord, the sale. Picks up the matter for sale. My lord, if your lordship kindly takes the summons for direction.
Item number 70.
60.
60. 60.
60.
PLG.
PLG.
Okay, 60, I think it will come because 44 till 43 only for correction. It will come, it will not, then you mention. Yes, call the list.
Number 1.
This court did not find any reason to allowing the terminal benefit as prayed for, but anyhow, taking into consideration that since 2011 you are getting only 2,000 rupees, that has been directed to enhance rupees 3,000 rupees. Medical allowance. Instead of 2,000 from the July 2025 onwards. Next.
Number 4.
No, that is not, that is so you call the 6 onwards.
For the official. This is like home buyers applications.
Actual two-part order was passed.
Yes.
But in the order portion, first 1, 2, 3, 4, second again in the has taken the second 1, 2, 3. But that serial number is to be correct.
Oh.
That's only, nothing else.
My lord, there's also one more submission. Can I take this advantage of this correction day? CA 81 of 2024. Your lordship will find that in the second part of the order, because there was a claim of 18,000, which the RP had said. We have tried contacting the RP. We couldn't contact him. Oh, we have contacted. My lord, this is the list. If your lordship has this last list.
Yes, 81 is here.
81, CA 81 of 2024, 18,000. My lord, we undertake to pay. It has been decided, my lord, if we can also come in the first part.
Okay, you go. That accept didn't mention, I will
deeply.
The matrix listed as to be mentioned for correction in the order dated. Okay. 18th June 2020. Item number 6. In the order dated 18th June 2025, this court has passed order in two parts. But in the second part, again, the serial number is and the paragraph serial number is recorded as 1 to 6. But the said paragraph shall be read this. But the serial number of said paragraph be continuously read as 12, 13, 14, 15, 16, and 17 instead of 1 to 6. This order may be incorporated with the order. In terms of this order, the serial number in the order dated 18/6/2025 may be corrected. Okay. Yes, call the list.
But if I can have that list, I just handed over. That is very important.
Well, was item 6 to 43 Avni matter mentioned, Malad?
No, only correction, the serial number, order serial number.
Oh, very well, Malad. I'm sorry.
Yes, call 44.
Item 44. I'm for the official.
44.
Milad, item number 44. Milad, I'm so sorry, Milad. My background is little bit awkward today, Milad. I'm unable to find any better background effects. I'm so sorry.
Nowadays, that background is a good greenery.
He's in
greenery.
the car.
No, Milad,
He's bouncing in the car with a green background.
No, I was trying to find out a better background, but Milad, I'm unable to. Milad, I'm flying, Milad. Now, Milad, the first application, Milad, was hearing, Milad, which has come back from Supreme Court. Now, Milad, this, the Milad, Mr. Guha, I think, Milad, he is present. Milad, let him press his application, Milad. Will reply, Milad. This is his application.
Yes.
My lord. My lord, facts are indeed.
CA 157.
Yes, my lord. Interesting and mysterious.
Yes.
My lord, allow me to, my lord, give your lordship a brief background as to, my lord, what has happened. Hey, where's my brief? Lordship kindly. Brief kothay? Lordship kindly gives me more. My lord, everything arises out of, well, two issues. One is a company and another is the probate proceedings. Well, they are both in a way, well, interconnected. If I give your lordship the basic background, your lordship will be able to understand. There's a company by the name of Notopod Dotto Properties Private Limited. It's a closely held family company of the Dotto family. So, well, three brothers had equal shareholding in the company, 33.13% each. So, well, this company, on a voluntary winding up petition, was wound up, and its assets and properties were put up for sale. This company, interestingly, had no creditors. So, the assets of the company were valuable immovable properties in the city of Calcutta. So, well, the as and when these properties were being sold in auction, the proceeds came to the official liquidator, and the beneficiary of the proceeds were the contributories. Because there was no creditors, it went back to the members, the contributory. So over the time, my lord, the three brothers, all three expired. So their legal heirs naturally became entitled to the my lord, the share in the proceeds of the company. My lord, one brother was Yudhishthir. Lord, kindly take the application first and kindly take the trouble of coming to page 53. So your lordship will find the genealogical table at page 53.
53?
Yes, my lord. 53 of CA 157. Volume 1. So we meet again. 53 is not the table. Soft copy আছে hard copy টা কোথায়? Well, possibly my learned friend's brief says 47.
So, boy, 53 something, some orders are there.
report. 47 is the.
Well, I don't know how,
47.
but in my brief it is 47.
47 is the genealogical table.
I see. I stand corrected, my lord. R47 is
Annexure C.
Yes, my lord. My advocate on record, he is not the previous. He has a আরে এটা নয় আমার My lord, in this matter, your lordship will find for the last 20 years I have been appearing in this matter, and consistently, my lord, there has been pagination problem and other problems as well. Okay, bolo na. Hey. আর তার মধ্যে আর একটা ইয়ে আছে স্পাইরাল বাইন্ডিং আছে ওই তো দিতে বলো জাজমেন্ট গুলো আছে My lord, your lordship will find the genealogical table which is at your lordship brief at 47 my 53. My lord, three brothers your lordship will find.
Yes.
My lord, your lordship will on the left hand side take Yudhishthir Datta. That is our concern.
Yes.
Well, Yudhishthir Datta had two wives.
Yes.
From his first wife, well, Robindranath and Animat was his son and daughter. And his wife, well, Yudhishthir Datta on the left side. Yes, my lord, on the left
side.
Two
wives. Okay.
Yes, my lord.
Bhanumati Datta and Kamala Datta.
Correct, my lord. From the first wife, which is Kamala, your lordship will find there one son and one daughter. Rabindranath and Anima.
Correct.
And then on the right hand side, your lordship will see Bhanumati is the second wife.
Yes.
From there, my lord, it is Arupa Datta and Atanu Datta. Your lordship has found that, my lord. The second wife is Bhanumati Datta.
Correct.
Immediately below that, your lordship will find
Apurva Datta.
Yes.
And Atanu Datta.
Yes, well, Atanu Datta. So our concern is here, my lord, the issue is between Atanu Datta, which is Mr. Dasgupta's client, and the rest on the left. So basically, it's the fight between the children of the first wife and the second wife. So, my lord, what had happened is, my lord, the present application, what is concerned, it's a company application. Now, my lord, what had happened is Yudhishthir Datta died leaving behind a will. A probate application was filed by Atanu Datta. Bhanumati Datta, I stand corrected, my lord. Bhanumati Datta, wife.
Second wife.
Yes, the second wife. This probate proceedings was contested by the son of Kamala Datta, that is Yudhishthir's son from the first wife, Rabindranath Datta. Became a contentious cause. Probate was granted by the learned single judge. On a contentious cause, a decree for probate was passed. In appeal, But the appeal court was pleased to set aside the judgment. And it became a reported judgment. The appeal court's judgment is a reported judgment. Against which, my lord, appeals were preferred before the Honorable Supreme Court. By whom, my lord? By Otonu Dotto. So, Otonu Dotto, so there was no probate when the matter was before the Supreme Court, because the probate was set aside by the division bench in appeal. So, when the matter went before the Supreme Court, my lord, Otonu Dotto, that appeal specially petition was pending for years together. At that stage, my lord, there is a compromise which happens. Now, your lordship will see the compromise happens. I'll show your lordship the terms of
pendency of the SLP.
During the pendency of the SLP, at that stage, in terms of settlement on a compromise happen. The compromise happens between whom? That is relevant in our case. Compromise happens between my lord Otonu Dotto and my lord one branch, which is my lord Rama, Shurojit and Sharbojit, which is the children of the first wife. So the children of the second wife, who are undisputed legal representatives of Yudhishthir Dotto, the original contributory, well, they were not parties to the terms of settlement.
So Ramo, Surajit and Sarabjit.
Yes, my lord. Your lord
So
will
they
be
are
the first wife.
they are the heirs of the Ravindranath.
Correct.
Ravindranath Dotto.
No, my lord. Ravindranath, Rama was his wife,
that's
and Shurojit and Sharbojit was
They are the
his
sons.
two sons. So Rabindranath died.
Correct. The legal heirs of the Ravindra entered into the compromise between the Athan.
Absolutely.
Correct.
Absolutely. Absolutely. Now, the other branch, which is my lord Onima, Arundhati and Aniruddha,
They are left out.
they were left out. So the compromise happened. Terms of settlement.
Compromise in terms of full.
No, my lord, the compromise happened in Supreme Court. Terms of settlement filed. Terms of settlement was filed before the Supreme Court, and Supreme Court passed an order. And I need to show your lordship that order. If I may just draw your lordship's attention to that order of the Supreme Court. It's just a one-page, naturally. Terms of settlement, Supreme Court was more than happy to dispose of a specially petition which by then had become a civil appeal. Correct. Dekho, এটা একবার দাও। My lord, I have indicated this to my juniors. There are certain documents which I need to bring to your lordship's notice, which are admittedly not a part of the company application. So if your lordship wants, I can file a supplementary. So though they are court records, like this order.
Yes.
Well, if your lordship will kindly see the order, a joint application dated such and such has been filed by the appellant. Your lordship will make a note of the appellant, Otonu.
Yes.
Dated such and such has been filed by the appellant and respondent number 1, 2 and 3. Number 1, 2 and 3, I'll give you lordship a copy
Rama,
of
Surajit and Sarabjit.
Kindly take the copy of the special leave petition, the cost title of the special leave petition. আমাকে একটা কপি দেবে যেটা দিলাম ওই পাতাটা আছে যেটা দিলাম second. But at second page your lordship will see 1, 2 and 3 are this branch, the first wife's branch. Now your lordship will see the others are parties as well.
Yes.
In the next page your lordship will see that Onima and the others are parties. Right. So they did not form a part of the terms of
Only
settlement.
Anima was there, but she is not the part of
No. Because she was alive at that point of time. To record a statement arrived at between the parties.
Yes.
Stop. The original of the terms of settlement has been signed by the parties.
Correct.
The application has been signed by the council. Stop. The terms of settlement are annexed to the joint statement filed by the parties. Stop. It will therefore be treated as an order in terms of the settlement annexed to the joint application.
Yes.
IAs and appeal are accordingly disposed of in terms of prayer A and B of the joint application mentioned above. Compromise application will form part of the record. Disposed of. Now, my lord, what happens? Interestingly, my lord, under the terms of settlement, my lord, I need to draw your lordship attention to the terms of settlement. Terms of settlement. Well, it's a part of the CA application, page 227. 226, I stand corrected. my lord.
Yeah, second part.
It is there in possibly the second volume.
227.
226, my lord. My lord, I don't know if the page is matching.
No, it's not.
It's not,
It's not matching. 226 is the High Court. High Court petition.
Lordship kindly gives me a move. Again.
May I just take it out from
Hey, my lord, it's that page. ये नहीं है. Terms तो इसके बाद हो.
You do one thing. It is better. Make the total document which you are relying upon a compilation. Sound copy to the other side. So that will be better.
Very well, very well.
Milord, with this awkward background, Milord, may I have my lords leave Milord only to stay one state one thing. That Milord, all the contentions that Milord with leave of also Milord, Mr. Bose Milord, my landed senior friend. That Milord, all these contentions, Milord, what he is now is putting before your lordships, Milord has been Milord already decided by the Honorable Supreme Court.
Yeah.
Milord, what he did, Milord, he had filed a recalling application seeking Milord recall of this Milord, this settlement decree, compromise decree, passed by the Honorable Supreme Court. Milord, in that IA, he has enclosed everything. It was Milord, I think, 3 to 4 volumes. Milord,
Yes,
I
sir,
had
for
that
me to
IA.
place that because now your lordship will look at the
He
Supreme
had this.
Court.
No,
I am grateful to my learned friends for
he has
pointing this out.
disclosed everything. Now, Milord, the Supreme Court, Milord, has Milord dismissed Milord expressly that
With
application.
liberty. Kindly look
With
at the
liberty to
liberty.
what? With liberty
Kindly
to
look
get
at the
his
liberty.
remedy.
So
Milord,
allow
now
the judge
doesn't
to.
mean that he will re-agitate again, Milord, before this
Yes,
Honorable
I
Court.
will. I will. That liberty has been given.
No, that liberty is not.
We
Milord,
agitate.
kindly
That's the
interpret that.
liberty. Kindly see,
Milord,
man.
where
I
it
am
is
not
been
saying.
written that he can re-agitate. Kindly see the Supreme Court order. Kindly see.
Okay, Mr. Dasgupta, I appreciate that the Supreme Court has not allowed the modification and recalling application.
Recalling.
Correct. That was dismissed and the court
That
has
was dismissed.
declined to entertain the application. Okay, no problem. But whatever it is, this court has to dispose of either of the way. So
Only Milord, I was trying to cut the matter short, Milord, because this is Milord, we have already won 2 rounds before Supreme Court.
Correct. That's
Last
why
year and this year.
That's why this court also want to, it should be stopped here only.
But unfortunately, my lord, Supreme Court wants, instead of Supreme Court taking up
I don't
the
think
trouble,
Milord,
Supreme Court has sent it back to us.
Mr. Bose, all type of the order with you only.
This is my fake. There I am defending one. There I am defending one.
That also.
There is one more liberty. Now, my lord, kindly look at the language of the liberty. However, your lordship has this order. But the Supreme
Yes,
Court order, kindly have a look at the.
Yes, however, liberty is granted to the applicant to work out her remedy.
Work out her remedy. Now, lordship will see what is the remedy.
That's
Milord, he has to
My
decide. He
remedy
can't
is
re-agitate.
when I say that I am entitled to a part of the estate of my late father or my grandfather now. So
Milord,
that's my remedy. So how can you take it away? So Supreme
Milord, in
Court has said
company
that
court
go
will
back,
get into a testamentary
agitate.
jurisdiction.
That's what I am
Milord,
doing.
kindly see Milord Justice Shobhashachi Bhattacharya's order.
This
Milord,
is
prayer
the
A
same.
has been disallowed. Already
Yes.
disallowed.
This order is
Prayer
passed.
A. Kindly see Justice Bhattacharya's order. And Mr.
Tell your
Shukla
lordship,
is there. If he can show Milord Justice Bhattacharya's order to your lordship.
Please. Yes.
At the time when this SLP was pending, well, this application was already filed. So, well, we are pursuing that same application because, well, the remedy what I am asking for here is the same. What I am asking for. Now, kindly see my prayer. Well, prayer A I cannot get. So, I am not praying, pressing for prayer A. But kindly take the prayers in my application. Kindly take the judge's summons, your lordship will find.
Document dated April 2021 issued by the Registrar Original Site, Calcutta is void.
No, well, this one I cannot get.
Okay.
That is going back to the probate thing. Now kindly take B. official liquidator High Court be directed to disburse to the applicant proportionate share of 1/15 share of Anima Dotto. So they are saying, what they are trying to say is that we don't have any share. If you have recognized me as a surviving legal representative of Yudhishthir Dotto, who had 1/3 share in the company, so all proceeds I will have proportionate share as a legal heir. So which fee, according to us, is 1/15th. So how can you so who will adjudicate that? I went before the official.
With deepest of respect, Milad, it can't be, because after the will has been probated, Milad, that has been
That is the case. So the will probate you failed in proving the will. Division bench dismissed your probate application. So when the SLP was pending, this fraudulent compromise takes place.
Kindly appreciate Milad my agony.
Selected
Milad, there
parties.
is no anxiety, Milad, there is no ending to a matter then.
And it takes us back to that age-old principle, my lord. If I am not a party to a compromise, that compromise cannot be binding upon me.
He took this
I was
point,
not a
that got dismissed.
So when I went
That
before the Supreme Court said that very well, I am giving you liberty, go before the appropriate.
No, Supreme Court has not said that to go before the company court.
Oh, that's
deepest of respect.
That is why we are before your lordship. Your lordship will decide that. So he has to wait. Right now he's in a fancy background, my lord. When he comes
No,
to
that's all right. That's all right. That
background,
I am also in awkward position.
I am sure he will have his chance. So allow me to, my lord, complete my submissions. Now your lordship will find this is the position. So, well, if your lordship wants that compilation of documents on the basis, so what are we asking for?
Okay. Come, just.
My lord.
Yes, compromise petition.
The terms of settlement. The terms of settlement your lordship will find is a part of my company application
What is the page number?
220.
220.
220, my lord. Lord, it's a handwritten typed copy is not there, my lord.
No,
Then
this
you
is actually, this is the better copy. This is the true copy. Drawn up copy. Now, I just wish to draw your lordship's attention to কোথায় গেল সেটেলমেন্টটা 22 আমাদের পেজে কোথায়
My lord will get the typed copy at page 67 of my lord's.
Possibility of errors are there, my lord. Your lordship, this is very well written. The handwriting is very good.
But
your lordship can look at it. Your lordship is seeing the terms of settlement. No, my lord, your lordship will see the name of the parties at page. I think that is the page
67 type.
In the probate case, who are the parties?
Now,
probate case, who are the parties?
Robindranath filed a caveat.
Correct.
Filed a supporting case. So it became a contentious. All were parties. So Robindranath was alive. So his heirs was not necessary. So Robindranath was a party.
Correct. Rabindranath was party.
Yes.
So Rabindranath had.
So it was the appeal of Robindranath which was allowed. Division bench judgment ada. Ajanath Rai judgment ada.
So Rabindranath is having one wife.
So the Rabindranath, when he died, his heirs were not made parties to the terms of settlement.
So
the other branch.
Anima Dattas were not there.
Yes. The Anima and the other one. Correct. Now, my lord, kindly see, this is the division bench order by which the probate was set aside.
Correct. Before at the time of passing of the division bench, Ravindra was alive or dead?
No, he was dead.
He was dead. When Ravindra?
Yes. That's why Rama came. Rama was substituted.
When he was substituted?
Rama was substituted during the pendency of the appeal.
During the pendency of the
Correct.
appeal. If during the pendency of the appeal, then Anima and Anima has not been substituted.
No, Anima was alive, my lord.
Anima was alive.
She was alive.
Anima was alive.
Yes, Anima was alive.
He died sometime
They
in
are right.
2005.
They are right.
Anima expired after the settlement decree.
Right.
My lord, may I clarify one thing? My lord, from the grant of probate by single bench, Rabindranath Datta preferred an appeal. Anima Datta did not prefer any independent appeal.
Right.
She was pro forma respondent in appeal of Rabindranath Datta. She chose not to challenge.
Correct.
My lord, from division bench, our client went to Supreme Court.
She was respondent there also. We have documents to show which we produced before Supreme Court that she was served notice from the registry
all along
and
by Dusty and also by Dusty.
service. They have taken all those points before Supreme Court. Recalling dismissed after considering everything. Dismissed.
So now Mr. Bose is appearing for whom? Anima?
My lord, yes, Onimas, the children of Onima.
Legal heirs.
Correct. So I'm grateful to my learned friend for pointing this out. So
But these are the facts.
Yeah, good. I'm very good. So when the appeal, the probate appeal was there, so all were parties. Now, when a challenge to the probate is there and the probate is set aside, so that means
zero.
So there is no probate in the eye of law.
Zero.
No stake. There's no question of any stay. At that point of time, Otonu goes up in appeal challenging the judgment.
Correct.
Now there's a settlement with some of the parties.
The three persons.
Correct.
Ramaya, Surati,
And not in respect of others. Now, whether you have served notice of that appeal or not, whether I have objected in our respective submission, it becomes irrelevant. Now the question is,
Okay. Continue.
No, Millet in 2001. Millet after the Supreme Court order.
there's a
That's Gupta. This is not clear.
Subsequently, in 2001, that is my background.
So your contention is that before the Supreme Court, when the settlement was made, you are not made a party.
Right.
Correct.
Right.
So though the Supreme Court has not accepted your application for recalling, given the liberty, now you wanted that the settlement is not in accordance with the law. You are also.
I am not on the settlement part. I am more on if you have settled. Good luck
You are
to
also
you.
entitled to both share. You are entitled.
By settlement, you cannot take away my right, which has come to me by operation of law. Now, what they are saying is, by virtue of the probate, the entire estate has devolved upon me. Now, in a settlement, your lordship knows, my lord, this is good law, undisputed law affirmed by the Supreme Court, my lord. There cannot be a probate through a settlement.
That has to be decided by a testamentary court.
That cannot
Not by a company court, my lord.
Well, my lord, today company courts have the trappings of the civil court under the 56 Act. So, my lord, there is only one court which he can decide. Now, today, my lord, what has happened is, now interesting, but this is very interesting. Now, when I go before the official liquidator claiming my 1/15th share as a contributory, official liquidator rejects the application. So I come before this court. Now kindly have a look at the order. This order is also not under challenge. My lord, kindly, no appeal by them. My lord, kindly have a look at the order which forms a part of my CA application. Again, page number problem, my lord. Page number, there are more than 500 documents. How will I show? My lord, I don't know, it should be 6th April 2017. There's an order of at page 318.
Second volume.
Lord, may I just do this? May I make this compilation of relevant documents, give them a copy and come back?
That better.
That better. Because the other application is even more interesting.
Okay, let me come with the compilation.
All the relevant documents I'll give it to you.
Kindly grant us also to disclose the documents.
Yes.
Report of Supreme Court which we use
Millet,
there.
allow us to Millet. I don't know whether I'm audible, Millet.
Now you are
kindly allow us also to disclose the IA filed by them.
Correct. Both the parties filed their compilation of the document which both the parties relied upon.
Very well. Kindly keeps it next Wednesday, Millet. It's all ready.
After exchange of the same between the parties, let me see.
Very well. Kindly keep it next Wednesday, Millet. We'll get 1 week in the meantime.
So. You are the applicant, Mr.
My lord, I am the applicant.
Swenson suffering for the applicant, Swenson suffering for the respondent, and Swenson suffering for the official liquidator. This court finds that this court is this case is having checkered history, and both the parties have relied upon several documents. For the convenience of this court, the parties are directed to file their compilation of the document which the parties are relied upon after exchange of the same between the parties within a period of 1 week.
10 days if possible.
Within a period of
Again, nahi hoga, फिर again you will create.
No, no, Millard, 1 week will do, Millard, it's ready.
The matter on
I
6th
take the responsibility.
July 2025 under the same heading.
Millard, may I seek one indulgence? But Millard, we seek one clarification from Mr. Guha. There are two applicants, Anirudh Datta, Arundhati. He is appearing for both the applicants or one applicant only, Arundhati Datta?
We'll give that clarification.
Come with that.
Great. May I just take back that Supreme? May I take your lordship's kind leave, my lord?
Yes.
Oblige, Millard.
Oblige, Millard.
And Millard, I again apologize for this awkward green background.
No, it's okay.
The rest application may also stand adjourned till the next day.
Which
16th.
application?
There are other application.
There are other two applications.
Number 21, 22?
Yes.
Yes, next, yes.
246.
44, 45 and 46.
46.
Similar matter?
Similar. No, related to the same issue.
My lord,
Same CP.
but in my application, my lord, there was a direction to the official liquidator to do the demarcation for a particular property.
I will hear all this. The 44 record along with the present application, CA number 26 and CA number 27, 26 of 2023 and 27 of 2024 be placed on the same day.
My lord, on CA number 26, your lordship, the applicant name is not appearing in the cause list, my lord. That also may be indicated, my lord, because it's appearing as NA. I don't know, my lord, why the applicant's name should be.
What is the name?
Ranjana Datta.
The department is directed that in the cause list in CA number 26 of 2023, name of the petition applicant
Ranjana Datta.
recorded as
Ranjana Datta. Grateful, your lordship.
Grateful.
CA number 27, my lord, I have filed the objection.
I have received the reply. My lord, in CA number 26,
the
I am also murdered filer. Though I am not a party, my lord, but since it
the
was
official liquidator CA number 27.
I-
In CA number 27, the official liquidator has filed affidavit in opposition. The applicant have filed their affidavit in reply. Let the same be cut with the.
My lord, I am not a party to the application, my lord, but since the copy was served, I got the leave from the
Applicant
Ranjana
as well
Datta.
as the counsel for the Ranjana Datta have filed their affidavit.
Millard,
in reply.
we are one of the respondents in that application. Millard, OL be directed to serve copy on us of opposition.
Millard, we are also respondent in that, Millard. Let a copy be served to us.
Conscious, I am appearing whereby I have used an affidavit in opposition.
In which matter?
In
46.
Item number 46. Yes, you are appearing for whom?
I am for some of the branches.
Whom?
For my lord Rabindranath Datta and my lord Shomit Datta. Both affidavits, my lord opposition, my lord, with the leave of the court, it was directed.
Let it be also served on us, Millard, because we have to need to see that.
The counsel appearing for
other respondent also be this.
IA number.
Yes.
IA number 27 of 2024. Learned counsel appearing for Rabindranath Datta
and Sushmit Datta.
Rabindranath Datta and Susmita Datta has filed affidavit in opposition. Let the same be cut with the record. The learned counsel is directed to serve the copy of the affidavit in opposition to all the appearing parties.
Oblige to us. Great.
All the appearing parties, and all the appearing parties are at liberty to file their affidavit in reply if any required.
Deeply obliged.
Next. 45, 46, 47 is over. 47.
Lord,
Milord, 47, 48 and 49 may be taken up together, Milord, because it's Milord, the rate of 47 will also, Milord, depend on 49, which is my application, Milord.
This is my Milord.
Here are
CA1 and CA2. Just a minute. Item number 47 is appearing for the. You are for the petitioner. Yes. Item number 48.
I appear.
You are and 49.
It's my application, Milord.
Your application. Okay. Let it start. What is your application for?
wherein I have prayed for disbursement of a sum of rupees 1 crore 30 lakhs 60,133 from the official liquidator
1 crore 30 lakh 60,133 rupees.
007 Milord. And this disbursement is made by the official liquidator who is in control of the company in liquidation to the Milord, the applicant being the Union of India. So here, Milord, the fact.
So you are applying for Union of India.
I appear for the Union.
And this application is filed by Union.
By Union of India.
Yes.
Milord, here, Milord, I place the
So
facts.
Union of India application is been contested by the official liquidator.
Yes, sir. Because an award was also passed in favor of the company in liquidation against the Union of India. The Union of India, one thing I will say this, Lord, they are supporting to this, Lord.
Huh?
Supporting to this, the applicant number 3. So that from this, I will find, Milord. And Milord, here, Milord, what happens, Milord? Milord, there was an agreement, Milord, with there was an agreement by the conservator, chief conservator of forest, and with Milord, the company in liquidation. And that is, Milord, has been annexed. Milord, in 1951, for exploitation of marketable timber from the forest of North Andaman and exporting the same to mainland against royalty to be paid to the government at various fixed rate mentioned, an agreement was entered into.
Agreement between whom?
Agreement between Milord, Milord, yes. Agreement was entered into, Milord, between the residents of India and Milord, the company in liquidation.
Company?
Company in liquidation, PC Roy and Company.
PC Roy and Company. What is the date? What is the 51?
The agreement is, Milord, the 31st day of August 1951.
Documents are not.
You are not disclosed that.
Milord, this has been given to the official liquidator.
No, in your application you are not disclosed.
None in application.
If your case is based upon the agreement, so where is the agreement?
Milord, only the averment has been made, Milord, but document has not been annexed.
Supply.
I will give.
Supply the copy to all the party.
I have filed an objection to his application in GO.
My learned friend has no rights, limited rights, Milord. Here I am You are appearing for whom?
I am appearing for Saurashtra agencies, Milord. Milord, in this GA1, CA1, Milord, I have, pursuant to the order of this court, I have filed an objection. The reason, Milord,
Okay, I will hear.
may I just one more thing, Milord, my right will accrue, Milord. I have a right, Milord, decree. He is claiming on the basis of a decree. I have claiming on the basis of a decree which is prior in date. And Milord, I have, Milord, prosecuted all the arbitration, Milord, which my learned friend will refer on behalf of, Milord, the official liquidator. I have incurred all the cost on behalf of official liquidator. And that is why, Milord, I have a claim on preferential, as a preferential creditor. Out of cost. That's...
Then, Milord, an arbitration clause is there, Milord, in this agreement. Milord, there were altogether 5 arbitration proceedings arising out of this agreement. Milord, in the first arbitration, Milord, there was an award in favor of Union of India amounting to 32,83,000.
What was the dispute?
The dispute is this, Milord. The PC Roy and Company, Milord, also filed a suit against the company in liquidation. And that was filed in 1960, before this honorable court. And when, Milord, ultimately, that suit was referred to arbitration. And in that arbitration, Milord, got an award of 29 lakhs rupees.
By
the arbitrator.
No, who has got? Roy and or the liquidator? Who got the award?
Milord, the PC Roy and Company,
They got the award.
an award against the Union of India.
Correct.
In one award.
Correct.
Milord, then, Milord, the and Union of India had 3 awards against the company in liquidation. And company in liquidation also filed a proceedings against Union of India, and that also went in arbitration. And there, arbitrator first passed the award that was set aside, but the appeal court said, for the interest of the creditors, the Milord allowed. And thereafter, Milord, the award of 78 lakhs rupees passed against the company in liquidation. Then, Milord, what happened, Milord? The company, Milord, saying that at the time of taking possession of the assets of the company in 1975, when the company went into liquidation, the report says, Milord, there was nothing in assets of the company in liquidation. But that is not the true, Milord. True pictures stated before this court, Milord. Here, Milord, in 1960 suit, this honorable court appointed Mr. Milord, the director of the Saurashtra, Kamdar, Milord, that as director of the Milord, this company as receiver, and directed that you sell off all the assets of the forest department in the Milord Port Blair, that is the North Andaman, and that assets were sold by the director of the company, but the director of the company has not filed any account to the official liquidator, nor before the...
How he has sold?
Milord, that documents are with me, Milord. This is admitted fact, they have sold it.
What?
Milord,
What was the property?
Property, Milord, kindly have a look, Milord. That is that at page here in my application itself. At page, Milord, kindly have a look. The list is there. Milord, that's 164. And before that, Milord, before that 163. The Saurashtra Agency Private Limited.
163. Yes.
163, Milord.
Yes.
163. Here the Saurashtra Agency Private Limited, what it stated here, 9th April 1981, to whom it may concern, under the order of the Honorable High Court, I sold all the movable properties as listed of Messrs. PC Rai and Company India Private Limited in liquidation, lying at Maya Bandar, Bajato, Austin 2 and Austin 4, and Interview Island of North Andaman to Sri R.N. Gupta, proprietor of Messrs. Jaiswal Metal Scrap Trade Company of Calcutta, Port Blair, and said sale was confirmed by the Honorable High Court at Calcutta
by its order dated 2580. All the said movable property may peacefully be delivered to above party, and should any police help for security against wild animal is sought by the party, it may be please be complied with on payment of usual charges. This is the Milord, and that here written by the Dayalal K. Kamdar, receiver. So the receiver was appointed in his suit by this honorable court before referring it to the arbitration, and here with the direction to sell, and it was sold, and this is the admission. And then the list is given next page. Metalscape Trading Company, formerly Jaswal R.N. Gupta, and we thank you for the letter under reference of dated 8th November 2005 regarding the above issue, and desire to submit the follow. We list the items sold by the official liquidator. Official liquidator in enclosed herewith marked A. The items still remain with lying at Interview Island are marked B. Delay of removal of the material was due to consequence being that our landed property and establishment was acquired by the Andaman administration for the purpose of airport runway extension. The process of dismantling and rehabilitation once again of our establishment for generation of regular income due to sudden demise of partner and father undersigned the settlement of the property. And then page 2 is this letter, and then list is given annexed to this letter. That is at page 166. Page 166 is the list of the assets. It's not readable, very old matter, but this is whatever the document we have received from the chief conservator of forest, we have annexed here, Here, my contention is this, these assets which belong to the company in liquidation were taken charge by the receiver, by the order of the court, and sold it, and the sale proceed was not accounted for. And now the same person is claiming against the official liquidator of a claim of 29 lakhs rupees which he got in an award.
So after this, what has happened?
Then
After this sale and they have sold. Receiver has sold the property to the scrap dealer. Then what has happened?
Then this arbitration award, they are in page 10. Kindly have a page 10,
So the arbitration on what point?
Here, there were non-payment of the royalty and other heads. So the proceeding started.
Royalty, see, royalty not with regard to the materials.
No, I am not talking about the
Royalty for what?
For
the log.
Giving
log.
Log
Royalty only for the timbers. Correct.
Milord.
Cannot be a material for the other materials.
Not
So where is the order for the log cutting and felling of the log cutting and transportation of the log?
That is in the agreement itself.
That's why it show that.
Yes.
If you are going by the royalty only for the purpose of if you are taken, if the forest authorities have given any permission to cut down of falling down the trees, you have to falling down, then you have to pay the yes. Then you have to remove at the time of remove. You have to get the transit pass, and at the time of felling down the tree, you have to pay the royalty as fixed by the administration in terms of the LR and LRR. That is the provision.
Here, detail, I am reading to part, This agreement of license was made on 31st day of August 1951 between the President of India, hereinafter called the licensor, which expression sale, unless excluded by or repugnant to the contest, include his successors and assign to one part, and Messrs. P.C. Rai and Company, India Limited, a company registered under the Indian Companies Act 1913 and having registered office at 4 Lions Range, Kolkata 1, hereinafter called the licensee, where expression sale, unless excluded by or repugnant to the contest, include its successors and permitted agents of the part with as follow. Then, Milord, the Chief Commissioner Andaman Nicobar called the commissioner is secured value of 10 lakhs for full. Then Milord,
Your agreement is not legible.
then Milord,
Your agreement is not.
para 4 Milord, para
Your
4.
agreement is not legible, sir.
Para 4 Milord, licensee shall have the sole right to
Cut, fell, and
extract all trees from clear felling area and tall trees marked by the chief conservator of forest, the Andaman Nicobar Island, hereinafter called the chief conservator or his nominee in the selection felling area in the forest of the North Andaman as per full description given in Schedule A, herein
under attached
and all other forest products in strict accordance with the approved working plan to for these forests by the licensor, which may be revised from time to time. The number, dimension, and species of trees to be cut will be determined by the chief conservator or his nominee in accordance with the prescriptions of working plan, which may not deviated from without previous intimation to the licensee. Then, my lord, the next paragraph is the rate. This is the yield from this forest is estimated at 75,000 tons. 1 ton is equal to 50 square meter in quarter, measured throughout this agreement. And then, my lord, year-wise the fixed. And then, my lord, I place, my lord, the
paragraph 12.
Paragraph.
Government shall levy the royalty.
Yes, my lord. Paragraph 12.
Fixed as per the proposition of the period.
Yes.
Of log.
Period free on
Price of log free on board.
Free on board. FOB North
Andaman independent of the
cost of extraction,
transportation,
overhead, etc. incurred by the licensee.
Correct.
The proportions of the LOB prices charged as royalty for the different categories of timbers shall be fixed
as follows.
Then, my lord, the
matchbox, plywood, and the handwood.
Royalty on firewood and all forest product other than timber shall be fixed from time to time by the chief conservator of forest. And however, that firewood in such quantity as shall be fixed from time to time by the chief conservator may be removed by the licensee upon licensee from of the royalty for the bona fide use of the licensee or his employees, but not for sale. The species of the tree that will generally fall under the different category in the foregoing clause number 12(1) shall be as in the schedule B. A particular log or consignment of a species that a common to the 2 or more categories may be assigned to a particular categories as the discretion of the chief conservator according to its quality, and his decisions shall be final in the matter. Additions and alterations to Schedule B may be made from time to time when and if necessary by the chief conservator. The price per
So after this, in terms of the clause 33, the arbitrator was appointed. There's a dispute.
Yes, then there is a provision that this payment clause.
Okay, whatever it is. So as per the clause 33, arbitrator was appointed. There was a dispute.
There was a dispute.
Yes.
And there were, my lord, altogether.
Who are the parties before the arbitrator?
My lord, before the arbitrator.
Who are the parties?
The Union of India was the party, and the
who was the claimant? Who was the claimant?
My lord, the Union of India was the claimant.
Union of India has filed a claim arbitration.
My lord, Union of India filed suit. filed suit against the PC Roy and Company, the licensee. And then, my lord, that suit, my lord, finally became referred to the arbitration because there was the arbitration clause.
Correct.
And then, my lord, the arbitrator made award. So there were 3 awards made in favor of Union of India. And, my lord, 1 award, and this company in liquidation had also.
What was the claim before the civil suit, which was referred to the arbitrator? Where is the civil suit?
Here.
What was the claim in the civil suit?
My lord, in page 3, my lord, I have said that.
Page 3 of the application.
Page of 3 of the application.
You are not having all documents.
My lord, my lord, here the details are there, my lord. That my lord, kindly have a look, my lord. The C, my lord, C. That in the first, my lord, the suit becomes arbitration.
That's why what was the claim?
Yes, it's stated here, my lord, that in the first arbitration, the liability arbitrator awarded the following award in favor of the Union of India: royalty on timber exported and consumed in the license mills up to the 31st 3/1961 and interest thereon
19 lakhs.
19 lakhs 41,299.70.
Local inspections.
Amount awarded towards local inspection.
So altogether 32 lakhs was awarded.
32 lakhs and
83,000.
34.85.
Correct.
In respect of 1 award.
Correct.
Lord, the suit has become the
Correct. No problem.
arbitration and award is there.
Correct.
So instead of the decree, it's award.
Correct.
Then, my lord, the second, my lord, then, my lord, Lord, I straightway come to page 10, my lord. Page 10, I have given the details that the, my lord,
yes,
that, my lord, that award in favor of the Union of India.
Page
10, my lord.
Page 10 paragraph.
My lord, this is, my lord.
Yes, got it.
My lord, the award in favor of Union of India. Serial number 1. My lord, particular first arbitration. Award amount due 24,62,988.85. Interest due 22,32,249 and total amount due 46,95,237.82.
Yes.
This is in respect of the first arbitration proceedings and award made therein in favor of the Union of India.
Correct.
Then second, my lord, arbitration proceeding where award made in favor
So
of the Union of India.
as per that, the Union of India has initiated 3 arbitration proceedings. All this award was passed. The total award was 1,30,60,133.
Yes.
Along with interest.
Yes, my lord.
Correct.
Then next is the, my lord.
The company has filed the arbitration. In the company, 84 lakhs award was awarded.
Yes, my lord.
Who are the company? Saurashtra?
No.
PC Roy.
Company. PC Roy and Company.
Okay.
And moreover, my lord, PC Roy and Company, there is no assets in the account of the official liquidator to make expenses for litigation. Then, my lord, this Saurashtra agency.
Okay, now I will come to that. So, so 3 award in favor of Union of India, 1 award in favor of the PC Roy. Then what has happened?
Then, my lord, thereafter, my lord, what happened, my lord? After this award of 84 lakhs rupees was paid by the court, my lord, then, my lord, in collusion with the, my lord, the execution application filed by the official liquidator. Official execution application against the Union of India for realization of this 84 lakhs rupees was filed before this court. And, my lord, this money.
Why the official you got the award in your favor?
I got
this 84 lakh.
Yes.
For the 84 lakh. Okay, got it.
Prove the date, my lord, then I will get.
Okay.
Here, my lord, the award in favor of company in liquidation. So company liquidation can execute. So, my lord, this in collusion with the liquidator, my lord, filed the execution application. Company has no fund funded by the Saurashtra. And here, my lord, this application was made before the court and then we placed before the court. that I have a claim against the company in liquidation about 130 crores and you have a claim of about 84 lakhs. So you make a minus of that and give it to balance. This proposal was given, but this was not accepted. And execution proceeding, there was an order that is a execution proceeding. Court will execute the decree. What if is there?
The Union of India has not gone for the execution.
Union of India cannot go in execution, because
Why?
this will be decided by the official liquidator.
No. What has happened to the award passed by the arbitrator? The award which you got, what has happened to the award?
Award which passed in my favor, then, I got a decree against the award, and then whatever the claim, was
Against
there,
the award
was
decree?
Post liquidation,
That's I'm telling you.
award,
it's 1940 award. That is why, a decree was passed by on order of the court.
47.
This is the 1940, first award will be passed, and then a decree will be made.
Correct.
After that decree passed, that amount claim was placed before the official liquidator, because under the Companies Act 1956, the official liquidator, if company liquidator, decide the claim, inviting all the claims. So I made that claim, But the claim which the company in liquidation has against any person, that can be executed without any formalities, that can be. So therefore, the company in liquidation has had a the decree, the award and decree in against the Union of India, that this company in liquidation executed through the official liquidator by filing an execution petition before this court. And there, I was directed to initially made payment of 50 lakhs rupees deposit. Against that, that direction of deposit the 50 lakhs rupees, I preferred an appeal before the division bench. And division bench said that if this amount is deposited, ultimately this will be the benefit of the creditors. And the Credit Union of India is also a creditor. And the secured the preferential payments also said the payment will be made towards the taxes and others. So court said the court, in that event, rejected the appeal, and then again back to this execution proceeding, and the Union of India deposited the balance 34 lakhs and odd before the
So Union of India paid the 84 lakhs.
84 lakhs rupees.
To whom?
To
the official liquidator.
Up to the official liquidator. To 84 lakhs rupees deposited with the official liquidator.
Then what has happened?
Then, what happened, Now the applicant number 31 company, Saurashtra agency, came by making an application. The CA3 claiming the 29 lakhs rupees and
against whom?
Against the official liquidator, and 7 lakhs rupees that towards the miscellaneous expenses they have made for meeting the cost and litigation. Nowhere provided in the act. And then made in this application, and in the process it revealed that the assets of the company in liquidation was sold by the director of this applicant 3, and the account had not been submitted before neither before the original side
Who?
by the Saurashtra agency. The director of the Saurashtra agency as a receiver, because as per the rule of the original side, 6 months in each 6 months the receiver has to submit the account with the department regarding the how much amount he has collected, how much amount in hand. So
how the Saurashtra has come in picture?
Because the Saurashtra filed the suit, and Saurashtra's managing director appointed receiver, and receiver sold the assets. So here the official liquidator saying that he has no knowledge of all these things. But here in this
when the receiver was appointed,
Lord, receiver was appointed, Lord,
And when the award, the amount of the 84 lakhs, the awarded amount was deposited by Union of India in favor of the official liquidator?
Milord, that is in Milord, this was deposited sometime in 2018.
18.
2018.
And when the Saurashtra filed an application?
Thereafter.
After 18?
Yes. Thereafter.
And when the receiver was appointed?
Well, I am coming to that.
That was prior to the liquidation.
That's I'm telling.
Was
Because
prior to
after the
liquidation, yes, not in liquidation.
Ah.
And my lord, the unsecured creditor, my lord, they were directed by the Supreme Court to contribute the, my lord, the expenses to be incurred by the official liquidator.
Correct.
But it not said that he can realize it. He said, I am willing to contest the matter on behalf of the company in liquidation. The court said, very well, you do it. But court never said that you will realize the all expenses from the official liquidator.
That order is there. That order was there.
Milord, that is annexed to my application, that order, Milord.
Okay.
Here, Milord, the receiver was appointed, Milord. Here it's there.
A receiver for what?
Milord, receiver to take possession of the assets of the company in liquidation and sell it.
Once the company is in liquidation, how the receiver can be appointed?
May I just indicate, Milord, there are certain things, Milord. Initially, Milord, I filed a suit in Milord Saurashtra Agency on 10 June 1960, when Milord company was Milord a subsisting company. In that suit, Milord, PC Roy and company, Milord, take out an application that the dispute between the parties had to be referred to the arbitrator.
Arbitration.
Milord, then the matter was referred to Milord the arbitration. Milord, in the arbitration, Milord, an award was passed on 28/11/1973. Milord, for a sum of rupees 29,36,113.63 paisa. Milord, that award was made decree on 11th February 1974. Milord, after that, Milord, on 10th June 1968, PC Rai and Company instituted a suit against Union of India. Milord, their Union of India made an application that the matter should be referred to arbitration. Milord, while all this process was going, and that was referred. While all this process was going on, Milord, one Vibhuti Bhushan Datto and Company initiated a winding up proceeding, that is, Milord, the CP number 203 of 9. And Milord, winding up order was made on 25/6/1975. Milord, Milord, thereafter, Union of India made an application before in the company court seeking, in between what has happened, Milord, the arbitration was going on for long. There are altogether 5 arbitration, Milord. There was dispute between the arbitrator, matter was referred to umpire. So Union of India said that I am incurring lot of costs. So they made an application before the company court for revocation of the, Milord, the authority of the umpire. While, Milord, we intervene and says that, Milord, this need to be proceeded because otherwise my decree, which is, Milord, 20 lakhs, will not be paid off. Milord, initially on the trial court, Milord, the company court rejected my prayer. I went up in appeal. Appeal court, Milord, says that you pay it off initially, and, Milord, there are direction to, Milord, conclude the arbitration, Milord, at a sudden time. That arbitration, Milord, culminated into, out of 5, 4 has reached its conclusion, Milord. 3 award in favor of Union of India, 1 award in favor of the companies, Milord. And today, Milord, that is, Milord, the factual situation. This, Milord, the appointment of receiver, if at all, Milord, as appear from the records, Milord, has happened in prior to 1980.
Milord, this is recorded in the order itself. This is recorded at page 32 of my learned friend's application.
And, Milord, this matter, Milord, this was, Milord, no, none of the parties could trace the order by which, Milord, this sale was confirmed.
No, I marked it. I'm sorry, Milord.
Therefore, Milord, this court on 17th October 2023, Milord, directed all parties, including, Milord, the official liquidator and the department, to trace the order on 20th, which is, Milord, 20th 2/5/1980. Milord, we have also from our end, Milord, applied for an inspection of the award. Milord, we have not received any response from the department. That order is not available, Milord. What, Milord, my learned friend's application is today, Milord, whether his claim can be treated as a preferential claim because they have made a claim before the official liquidator, official liquidator has adjudicated the claim to the 56 lakhs. I have made the claim before Milord, the official liquidator for my claim on account of decree and Milord the cost. Official liquidator has adjudicated Milord as my claim as well as cost, which is as a preferential claim, Milord. What my learned friend is claiming that since it is Milord a claim was an account of royalty, he should get a preferential payment in terms of 530. That is probably, Milord, is the substance of the application, Milord, as relief prayed for, Milord. And Milord, that subject to correction, Milord, that is, Milord, all these appointment, this is, Milord, whether I have sold.
The documents is required, all orders are required. Without the orders you are mentioning, you're doing, but
Milord, I have annexed the orders of Milord, the award in my favor, Milord. The
you are, but they are not having anything.
The specific order from this honorable court, Milord, directing the official liquidator to produce the record. And also the Milord, it was direction upon the Milord, the Saurashtra agencies, whose director, managing director was the
That
receiver
is different.
to produce the record.
It is you, Union of India is claiming you should have been all the documents. Even your agreement is not in proper form. All the eligible copy of you're placing before the court. Where is the award? What was the genesis on that?
Award has been annexed.
And where is the order of winding up? Where is the order of the liquidation? Where is the order? All the things has to be looked into. Not a simple seat. You have a 3 award. These having 4 award. You have paid the amount. Now you are required. You are the preferential creditor. You have to pay that. It cannot be. Court has to look into each and every document.
Here is the Milord disbursement now. At the stage, there is no other creditors. There is no workman claim. Milord, here is the disbursement. The amount which is lying in the hands of the official liquidator. Finally, company has to be, Milord, to be wound up now. Milord, now there's
How the liquidator has got the amount? Whether the company was sold?
Milord,
The award amount which they have deposited, that is
is
the
there
only
only.
thing we have.
So the PKR has not having any company. Where is the is there any auction of the property?
Milord, here, Milord, whatever the amount the official liquidator has accumulated on account of the company in liquidation, that has to be disbursed.
Correct. So now he is also claiming. So bring all the documents.
Milord, what question is here, Milord? Can he claim when he has not furnished
court
the
has to
account of his
that is
receiver?
the court has to decide
Milord.
if he has a claim. You are telling that he cannot claim.
No, I am saying, Milord, he got an award of 29 lakhs rupees.
Who?
Milord, the Saurashtra agencies.
Saurashtra agency.
Against the company in liquidation. Milord, then, Milord, that amount, Milord, is coming within the priority payment because the Milord, the Union of India has a claim against the royalty revenue.
So that has to be decided.
Milord.
That has to be decided.
Yes.
So that's why for the royalty, as per the agreement, these are the trees, these are the logs, these are the cubic meters of the log, this royalty. So what the calculation has come by the come to the conclusion by the arbitrator, that has to be seen.
Yes. Now, Milord, all culminated in award. So this, Milord, award is there, Milord. Your Lordship will look into the amount of the award.
So that's where is the award?
Milord, that is, Milord, annexed, Milord, here, Milord. All 3 awards have been annexed here.
Where is the award?
Here, Milord, kindly have a look, Milord. That at page 19, Milord. Page 19 starts. Annexure B.
Yeah, this is one award.
This is the one award.
Yes.
And then, Milord, Milord, another is, Milord, page 53, Annexure C.
Yes.
This is the award case number 142. And third is, my lord, that that is, my lord, at page 97.
Yes.
Award case number 140.
So these are the three awards.
Yes.
Correct. Then
Then, my lord, the affidavit of proof of date is given, my lord, at page 93. There are two affidavits.
which award was set aside?
Notice that award which was set aside against the company in liquidation, then it was in appeal court that was restored. Then the execution proceeding filed.
Appeal succeed, a judgment on single bench is set aside. So there is no workers. No workers has come forward.
No secured creditor, no workers.
No workers. So court has passed an order. If the award is sustained, it would be benefit firstly to worker, then the statutory creditor. That would be include the Union of India.
So that's why the Milord was restored. Here, Milord, the Union of India was said that he is also the Milord, the preferred creditor. So therefore, we should not restore the award. So therefore, it was restored. And they did it at their own risk. They spend the money. Unsecured creditors, they are going on spending money.
Yes.
Here, my lord, and I had placed, my lord, the orders of this honorable court, my lord, that court wanted explanation regarding the, my lord, the sale of the assets of the company from the official liquidator as well as the applicant number 3. And the managing director of the applicant number 3 was called personally. My lord, the warrant was issued. He appeared before this.
Managing director of?
My lord, the Sarastra agency, a company. It's a company of Gujarat. And my lord, then first did not appear. Then the warrant was issued. And then the...
In which proceeding?
In this proceeding itself.
This proceeding?
Yes. And my lord, then my lord, at that time, my lord, the Sarastra agency prayed for filing the affidavit in opposition to my application. And matter was, my lord, then deferred. And since then, matter didn't come. It's an old matter, my lord.
Where is your application? You filed when you filed application?
My lord, my application is, my lord, CA3. My lord, that is, my lord, I am seeking, my lord, direction upon the official liquidator.
What is, yes.
To make the payment of, my lord, my decretal amount and, my lord, the cost I have incurred.
Which decretal amount?
My lord, as I indicated, my lord, in 1960, I have filed a suit against the company in liquidation, my lord, which was referred to arbitration, and subsequently, my lord, a decree award was passed in my favor on 28th November 1973 for a sum of rupees 29,36,113. That was subsequently culminated into a decree. I had been, my lord, fighting on behalf of official liquidator and, my lord, investing my money to the official liquidator, because unless, my lord, there is fund to the, my lord, company's account, I would not get. My lord, now, my lord, that would be the question, my lord, whether they will at all come within the purview.
Division bench is
Division bench, my lord, will see it was never argued. My lord, my learned friend will have to satisfy your lordships that whether my learned friend's claim would come.
Division bench kindly come to the order of the
Yes, my
division
lord, I have
bench, just
seen
the penalty order.
that said, my lord, if your lordship sees, my lord, in 157, that says, my lord, that would include, my lord, the Union of India.
Correct.
My lord, all the claims of Union of India possibly will not. There are 4 arbitration, my lord. All of them will not possibly come under the purview
What
of.
are the claims?
My lord, they have claim, my lord, on account, my lord, in order to sustain a preferential claim within 530, my lord, the claim has to be, my lord, in respect of the years, which are 12 years next to the date of winding up order. So 1975, my lord, the order of winding up passed. Union of India will have to show that all these claims are, my lord, arising on 1974 to 1975. In their own pleading, they say this is the claim on account of 1961. So how can that, my lord, if your lordships, my learned friend application, that is GA1, as page 3, they say, my lord, when they given the chart, say royalty on timber exported and consumed in the licenses mill up to 31st/3/1961. So, my lord, 1961 claim of royalty.
All the awards of the this royalty only. All the awards are all royalties. Yes. Why 3?
Different
Phase.
Year.
phases.
Different phases.
So, my lord, for 1961, my lord, it can in no way, my lord, come within the purview of 530, my lord. They may 1 or 2, my lord, out of 3 years, they will have to demonstrate before your lordships that in effect, my lord, because division bench, this point was not urged. The division bench says, my lord, my award, which, my lord, the award in favor of company was initially set aside by the learned single judge. That went up in appeal, and division bench says if the award is sustained, every creditor will be benefited, and statutory, which, my lord, that is not a decision on merit. My lord, today, before your lordship, when they claim they are a preferential creditor, they'll have to demonstrate, my lord, they are coming within the purview of section 530 of the Companies Act.
Okay.
So, my lord, otherwise, my lord, and my lord, even my claim is 29 lakhs on decree, my lord, and my lord, 6 lakh, which official liquidator says as a preferential claim, 6 lakhs and odd, which I have invested, my lord, pursuant to, my lord, order of the division bench, which your lordship will find in my application, my lord. That is, my lord, CA3 at page 16. This order of the division bench, my lord, it start, my lord.
What? What? क्या मांग रहे हैं? What book you got? Which book?
Companies Act.
Companies Act here. 56.
Yes, I have.
नहीं है. No, हाँ से.
56 Act. CA3.
Yeah, then?
Yet, my lord, at CA3, my lord, page 22, this is an order on 19 September 1979, passed, my lord, in an appeal number 81 by 1979 by the Honorable Division Bench of this court. My lord, there, my lord, this order appeal was preferred by the Saurashtra agency, challenging the order whereby, my lord, the revocation umpire, my lord, the authority of the umpire was revoked at the instance of the Union of India. At the last paragraph, which is at page 37, internal page of 16, my lord, the court says we direct the appellant shall at the first instant bear and pay fees of up there, also at the first instance all the expenses conduct in the arbitration on behalf of the official liquidator. On this basis, my lord, I have, my lord, paid. My lord, the order starts at page 22.
So it has been given to the umpire.
Yes.
What has happened?
No, Milord, I am not on Milord the outcome of the Milord the arbitration. I am on the fact, Milord, that I have paid the fees of umpire, the advocate's fees, that is in terms of this order, which is appeared at page 37 internally, that is a claim of 6 lakhs and odd that official liquidator admits as a preferential claim, because Milord that would be coming under the Milord that's a cost of winding up, because otherwise they would not. These are the two claims of mine.
What is your claim now?
Milord, today my claim would come to Milord. Milord, I have claimed Milord 29 lakhs 36,113. That is my judge's summons, Milord.
How 29 lakh?
That is Milord in terms of the decree as admitted by the official liquidator in Milord under the provision of the Companies Act. Milord, we have submitted my claim before the official liquidator, that has been admitted. Milord.
Okay, you do one thing. You both come with the total compilation of all the documents. You're not having all documents. What can be done? Yes, what is your contention?
My submission is that this the Union of India, they have submitted 3 affidavit of 3 proof of claim. That is one in respect of the 21 lakhs 70,000, one in respect of the 28 lakhs 77,000, and another is in respect to 29 lakhs 21,000, 21 lakhs, and my lord, other is that is 24 lakhs.
That is
So
in terms of the award.
Yes, they have submitted the claim before the official liquidator for adjudication. In that claim, they never said interest. Now they are claiming interest towards as of that day. That they are not they permitted. Under in the liquidation proceedings till the date of the winding up order, they are entitled. Now they are asking for further interest also. So I shall satisfy your lordships with regard to the adjudication of the claim. First adjudication was rejected because the Honorable Court was said that please make a further adjudication. Further adjudication was made, and my lord,
Where is your adjudication?
That adjudication was the last occasion. I have handed over to your lordships the report copy. 23rd. Last adjudication was made in the 14th August 2023. But in my affidavit in opposition, my lord, I have clarified all these things.
Have you got the report?
Yes, last occasion.
Last occasion.
Last occasion.
Ah.
And Milord, I have
Every
to
occasion,
this
Milord, I can
because
show
I
the
have to say that the Saurashtra agency is not entitled for any amount.
That
which
is
they have.
different thing. Have you got through this?
I got it.
Yes. You will not file any option this.
Earlier report, I had filed exception, and that was set aside.
That is set aside. Now this
Then,
is the new. Now
again, the same thing has been repeated here.
So you will not take the exception to this report.
My client is in the port player. It's unable to come here to affirm this.
Okay. So you will not file.
I am Milord handicap in that.
Yes.
Both are the unsecured creditors. According to the official liquidator, both of them, so my lord, I have got some amount. According to me, if they are agreeable, my lord, regarding the distribution, my lord, which has been reported in by the official liquidator, if they accept it, I can pay it off.
So far, the interest is concerned, my lord, in the company code rules 1959, it has been provided.
What?
It is provided that regarding the on any date a certain sum payable a certain time otherwise, where interest is not reserved agreed, or which is overdue at the time of the winding up order, the resolution case may be creditor may provide for interest at the rate not exceeding 4% per annum.
Interest is different thing. First, your claim is to be decided first.
And in claim, my lord, also in agreement, there is a mention that the my lord licensor would be entitled for interest at the rate of 12% in case of default in payment.
How they will pay if there is no amount?
This is against the my lord the company in liquidation.
Correct. Company in liquidation. Company in liquidation only you are deposited the 83 lakhs. Company is not having any assets. He has not sold any. He did not get any profit, any assets from the company. So how the liquidator will give the payment to you as per your claim?
Therefore, whatever the amount lying with the official liquidator under section 530 in entirely it will go.
So
to
that's
the
why it is only the
That
83
is the
lakhs
only
what
way.
you want
And
to
remaining
require.
amount has to
Assuming
forgo.
he is not within the 530. That I shall satisfy your
Okay.
losses on the next day.
Okay,
No,
come
keep
on.
it parted, my lord. My lord, let the matter be kept parted, my lord.
What part at company
My
matter?
lord, if there is, my lord,
No, no, I
your
will not.
lordship kindly fix it, make it parted, my lord.
Yes, why?
Lord, yes, my lord. That is item number 60, my lord. 60.
The
order. But if your lordship kindly takes the summons for direction.
Date fixed. Matter will appear again on next Wednesday. Record an order. Census suffering for the applicant in CA number. Your CA number? CA3. CA 133 of 2018. CA 133 of 2018 suffering for the applicant. Census suffering for the official liquidator. And census suffering for the your intervener in the CA 133.
Yes, my lord.
Intervener. Full stop. Census suffering for the applicant in CA3. Census suffering for the Union of Indian. Census suffering for the official liquidator. Counsel for the respective parties argued the matter at length, but due to paucity of time, hearing could not be completed. Let the matter appear on 2nd July.
All three matters.
सब तीनों एक ही में कर दो. Yes.
In this regard, my lord, there was a typographical mistakes in the earlier valuation report, so that is the reason for which learned valuer was, my lord, requested to make a fresh report. The original.
Where is the report?
Original has been submitted, my lord. It was only for correction, so that correction has been done.
There is the report. Huh? The first report. Yes, where is the report? Which
page? Origin?
Page 2. Page 2. Page 2. 1702 to 2096. That's
which page?
2096.
Page
Page number 2.
Page number 2. Page number 2.
My lord, after
serial
the,
number?
My lord, serial, both the plots within bracket 108/2 in the middle of the my lord, page number.
Reading.
Data, no.
290. Typing computer.
But in the middle, my lord.
Show me from there.
আগের দিকে লিখে রাখেন না কেন? কোথায় এটা? কোথায় কারেকশন করেছেন? কোথায় কারেকশন করেছেন? দেখা। আরে এটার সঙ্গে এটা মিলছে না তো। এটা কি? এইটাই তো আপনার নাকি?
না। অন্য ম্যাটার।
এটা অন্য ম্যাটার। PLG দেখুন 60. This is another matter similar. It's not the same. PLG.
Item number 60. 60.
PLG. CA14.
It is just
CA14.
ये तो Ruby Star है. Yes.
Page number 2, it is written both the plots, so and so, commencing on 18th February 1990, ending on 17th February 1996. That would be 17th February 20996.
2096.
Yes.
Ending on 2096.
Ending on 2096. 17th February 2096. Well, that is leasehold land. So lease will expire on the 17th February.
Where is the lease date? Where is the lease date?
Where is lease deed? Where is
Lease deed already submitted.
lease deed?
Official submitted.
रिपोर्ट में है देखो लीज है ऑफिशियल लिक्विडेटर का रिपोर्ट है
Lease deed. No, it was submitted by the bank, my lord. They have shown the official liquidators and my lord the valuer. Not submitted in the court.
So how you can say?
Lord, I have not seen because it was under the cover and I don't have my lord, the copy of this. এটাই তো correct. He is saying, my lord, the lease will expire on 17th February 2096. Previously, it was written 17th February 1996. So that should be, my lord, the 17th February 2096. 2096.
So that's where is how he came to conclusion that where is that lease?
Lease are already submitted to the bank.
That copy must.
Very well, my lord, kindly keep this next week, my lord.
Bank submitted. List.
Because that he is telling
Yes,
that.
yes,
Na?
definitely, my lord.
If it is a date, then I can correct this order here.
Yes.
Commencing from 19. In the last, it's okay. You are Alok Ganguly. Total value of this assets is so and so 70 year, which is commencing from 18 to 1998 and ending on 17 to 1996.
Yes.
So and so suffering for the official liquidator. The approved. You are the approved valuer.
Yes, my lord. He is the approved
valuer. Mr. Alok Ganguly is present in person. He has submitted the valuation report. He has submitted the valuation report with respect of the property bearing ghat number 942 to 942 to 944 and 946 out of the land plot number 108 by 2, measuring an area of 1,423.00 square meter, wherein the approved valuer as in the conclusion part has held that total value within bracket movable and immovable of assets, including leasehold land for remaining 70 years within bracket remaining years 2096 minus 26 फिर एक bracket करो from 1998 to TO2 2024 equal to 26 years bracket close equal to 70 years comma which is commencing from 18 to 1998 and ending on 17th February 1996. But in the second page in the middle, it is recorded that both the plot within bracket 108 by 2 and 65 at ghat number 940, that's 940 to 944 and 946 are leasehold lands for the period of 1998 years commencing from 18 to 1998 ending on 17 to 1996.
full stop. The उसको not come across. The valuer submits, the valuer appear in person submits that the ending year is to be read as 17/2 is to be read in the valuation report at page number 2 in the middle as 17/2/2096. That is,
yes,
instead of 17/2/1996. In view of the above, in the report dated, what is the report? Date, what is the date? Report dated 16/12/2024. Submitted by the approval valuer Sri Alok Ganguly. In page number 2, the ending date shall be read as 17 February 2096 instead of 17 February 1996.
my lord, your lordships kindly accept the valuation and fix a reserve price and pass in terms of order C and D. And E.
Considering the above, the full stop, this court has considered the report and find that there is no impediment to accept the report. Accordingly, a report submitted by the valuer dated 16th December 2024 is accepted.
And my lord, fix the reserve price and my lord, the prayer C and D and E.
The official, give the master summon. The official liquidator has filed the present application being CA 14 of 2024, praying for several direction. In view of the above, several direction. Consider this application made by the official liquidator and the valuation report. Prayer
C, D and E. Prayer B already your lordships accepted. So
prayer C,
B, C, D and E.
C, D and E.
Yes. At this junction.
Is allowed for the present.
Kindly, my lord, fix the date of sale and my lord, 4 weeks.
So list of the official liquidator is directed to auction the property by way of sale, na?
By way of sale.
Sell the property by way of auction. By railtail?
Yes, my lord.
By railtail.
Well, the prayer C already your lordships passed.
Yes,
prayer C there. Only thing was a time, my lord, 4 weeks or whatever.
The official, okay, then the official liquidator is directed to hold the auction of the property on
within 4 weeks, my lord.
Date is to be fixed on.
Yes, my lord, kindly fix that.
On 4 weeks. Today we are on 26, na?
Yes.
25. So let it be on 29th of July.
29th.
On 29th July from 9 a.m. 10 a.m.
10 a.m.
10 a.m. till the completion of the sale process.
And while filing a report, my lord, to file a report next day.
Full stop. After completion of the auction of the property in question, comma, the official liquidator is directed to file the report by 28 July bola na? 29 on 6th of August 2026.
I am deeply pleased.
Lordship, when we permitted to mention item number 69. Item number 69, Your Lordship. I'm just praying for 3 weeks adjournment in this matter, Your Lordship, because
come. 3 weeks.
Lordship, item number 73. There is a little bit of an urgency in that matter, Your Lordship. It's been
next week. It will come next week.
Lordship, it actually is coming. Always, it's coming way below on the list, Your Lordship. I'm only praying if this can be kept in top of the list. A very short matter, Your Lordship.
Top that is there.
Item number 73, Your Lordship.
73.
73.
What is the urgency?
Lordship, I as a banker have been deprived of a huge amount, almost close to about 4 to 4.5 crores by another bank. See, this is an issue between two banks, Your Lordship. Indian Bank, there are a lot of banks which are involved in this matter, Your Lordship.
Come on that day, I will mention, I will see to that.
कुछ बोलिए रीडर साहब को बोलिए। अरे यार भाई